Lord, with your lordship's kind indulgence,
Yeah.
I'd like to mention item 27.
Sir,
I have taken the consent of Mr. Kaustav Gogoi, who is appearing as a standing counsel higher secondary education. It may come up after 4 weeks.
after 2 weeks, Mr. El Dotto, learned senior counsel, assisted by Mr. So and so, with consent from the other side, press for listing of letter after 2 weeks. Yeah.
7.
Much obliged.
May it please, my lord. Prepare for listing of a motion matter, if it pleases, my lord, on Monday.
When?
Monday, my lord. I'm deeply obliged.
My lord, these two matters may be listed on Wednesday for admission, my lord. Two matters.
May it please your lordship, my lord, with regard to item number 39, my lord, bail matter, my lord. I have the instruction to withdraw the matter, my lord.
Sir, Mr. Murwa, learned counsel for the skills. It's that he has the instruction to withdraw this case accordingly. Yes, that application number. Schools are on withdrawal.
I'll oblige it. May it please your lordship. Lordship, I beg to mention for listing of two admission matters, my lord, next week, my lord.
Take it that part.
May it please on list. 10th, we have other cases also. 7th and 8th. One, lordship, one may be listed on next week, my lord, at least one. 8.
May it please your lordship. Listing of an urgent matter on Monday. My lord, what has happened? The doctor here is working in AIMS Institute and she is a victim of sexual harassment. Despite there being a court order of the court that no course of action should be taken against her, notice of termination has been issued and it has been issued day before yesterday and it ends on Monday, my lord. That is why, my lord, there is an urgency, my lord. We've already filed the case, my lord. Much obliged, my lord.
Lord, I beg to mention contempt case, my lord, on Wednesday next. Wednesday.
Well, item number 40 is a contempt case. On the last occasion, the department has submitted one order, said that it is complied. However, I will challenge in a writ petition. The matter may be closed, madam.
It is already complied, your lordship.
Item 40.
Sir, taken up learned counsel for the petition submits that the order violation of which is challenged in the is number 211 of the 90. Submits that the order has been complied with and he will send the compliance order by filing one
6.
petition.
Respondent 6.
That accordingly he submits that the contempt case may be closed. Accordingly, taking over the petition, the contempt case stands closed. Granting liberty to the petitioner to evade appropriate remedy.
And 1 and 6 in contempt.
It's a 64, 1 and 6. That's how.
May it please. I beg to mention for listing it is on matter, my lord.
When?
Next week, my lord.
Take it that from.
Right.
I beg to mention listing, my lord, for listing WBC.
When? When?
Next week.
76 or 10. And also, column?
Admission.
Also,
Admission. Full admission. Wednesday for you. 10th.
Lordship, I beg to mention item number 19, your lordship. Some instructions are awaited. I have taken consent from the standing.
Item number 30.
19, 19.
Sections are awaited.
Instructions are awaited.
Yeah.
I have taken consent from.
Mr. B.J. Mukherjee, learned counsel.
One by counsel.
Consent of the other side.
After 2 weeks, your lord.
After 2 weeks.
Lordship, I like to mention an WPC lordship 3685 of 2025. This is also regarding a lordship selection process. Let it come on Wednesday, lordship. We have some urgency. State has some urgency, lordship. Wednesday. Next Friday. Thursday. Thursday. Oblige.
May it please, your lordship.
I beg to mention item number 30 and 31, Your Lordship. This, I have taken consent from the other side, Your Lordship. In these two cases, Your Lordship, we had prayed for regularization of service. And in fact, they have, their services has been in the meanwhile regularized, Your Lordship, few days back. But I am waiting for Your Lordship, receive instruction from them, Your Lordship, to withdraw the case. Maybe taken up next week, Your Lordship.
Mr. Albert, for learned counsel for the petition, we contempt the other side, but
Lordship. Obliged.
May I please, Lordship?
Yeah.
In respect of item number 47 to 51, my lord, my learned friend in the finance department has given me one instruction, my lord, that they have given concurrence with regard to 3% increment of the grant of increment to the petitioners, my lord. So in view of the above, my lord, the impugn orders may be set aside, and when, my lord, the education department will be directed to comply with the comply with the.
You have the Lordship, point 7, Lordship, the relief sought by my friend has been granted. Point number 7, Lordship, the 3% increment.
Finance department has given their concurrence.
Yes, Lordship. Lordship, in only in respect of the petitioners, Lordship, because we have received a proposal only in respect of the petitioners in this case.
yeah,
Petitioners?
Yes.
Only in respect of petitioners.
That-
And in view of the above, my lord, your lordship may
pass the order.
please to direct the education department to grant the the benefit.
Now, execution has to be done by the.
Impugn orders have to be
Set aside. Disposed of, my lord.
disposed of.
Obliged.
Sorry.
The judgment violated is at page 63. Notices to go at this stage. In similar violation, your lordship has already issued me.
But the next that is fixed,
Yes,
no, in other cases. Next that.
yes.
No. Notice issued, all right. But when the next date is fixed,
Oh,
in that case, we may take this matter with
Yes,
that
yes,
person.
I understand.
Sorry.
There are many matters, I mean, many, because so many writ petitioners are there, many dates will be there. Ultimately, it has to be clubbed together. So we'll have to find out. But this is one case where it can go along with that.
So we'll take this matter with this.
Yes,
Professor Details learned. Council assistant minister,
Legally done.
learned council for the petition. Its application under section 11 and 12 of the Contempt of Court Act 1971 related to article 200 of the Constitution. And rule 9 of the Contempt of Court. Rules 1977 for any setting contempt proceeding against the contempt of response. Where is the petition? Let's the order. It is. Eight, 1/20/25. Is it the correct date? 8/1/2025?
yes. Same respondent.
It's notice to the respondent returnable in rates that indicated by registered goods with ADN also in the process within a point. The learned counsel for the submits that similar situated petitioners have also initiated one contempt case saying contempt is or 4, 5, 5, and the present is by the take with the information. Contempt is number 4 to 5.
হেভি টু নাই হলে আপনার দিস
That is all. Take this matter forward that
independent of
5, 5, let's stop for this.
Right.
Order at page 24, Lord Chief, and relevant portion at page 30.
Order dated 12/6/20.
Lord Chief. Para 15 is the relevant portion.
Order dated 12/6/20.
12/6/2025.
Ordinance are scheduled to submit. Section 11 and 12 of the Contempt of Court Act 1971 related with Article 100. Yeah. By the applicant for drawing a contempt proceeding under Contempt of Court Act 1941 against the contempt or respondent contempt or willful disobedience of the order passed by this court in WPC number 1991 of 2024, dated 12/6 of 2025. Where is the petition? That of the order is exalted. It was notice for the response for return of net for submit taken by ABM of the process within every this subject for issue.
Obliged.
May I please your lordship? Lordship, in this contempt petition, operative portion is at page 30, para 7. And the link case is in page 25, WPC 2862 of 2024, Arati Borga and 500.
Third is the
SK Laham.
learn and concept for of this deletion under section 12 of the contempt of court act 1971 related article 1 is to be part by the applicant. Part by 6 petitioner for willful and deliberate violation of the order in 2025 of the court within WPC number 2862 of 2024. Part of the petition. The order dated 28 to 2025. It's no notice for the response returnable for its the taken by the server in ABM of the this after for its
Obliged.
Please, your lordship, my lord, this matter relates to compassionate appointment, my lord. The DLC decision is page 41, my lord.
Your lordship, we have received instruction, DLC approve your lordship.
Then your lordship may dispose of the matter with the direction to place the matter before the SLC, my lord.
or so very learned government advocate for the contact number
1, 1, 3. 1 and 3, your lordship, and 6, your lordship.
and 6.
Yes.
Madam Sophia for that's contact number 4.
4 and 5.
4 and 5. Petition number
Your lordship, I am for 2 also.
For issuing direction to the respondent of is to file the proposal of completion and appointment of the petitioner before the SLP of PLC. Madam, the case of the petitioner has already been approved by DLC on 15/6/2024.
Yes,
It has already been mentioned in the petition. Their grievances, the matter is not placed before the SLC.
yes, now it will go for SLC approval, SLC's approval, Your Lord.
Whether it is placed or not.
Now it will place, Your Lordship, since DLC has approved.
No, before filing of the petition, the case of the petitioner has been approved on 15/6/2020.
And here, instruction was sought from the department, my lord, regarding availability of vacancy. Subsequently, it was, my lord, approved. my lord.
In the paragraph number, in the pair portion, that paragraph number B, pair number B, it is mentioned that already been approved on 15/6/2020.
Yes, my lord. Subsequently, now they are to place before the SLs. Only a direction of this honorable court is required for placing the matter before the SLC, since the DLC has already approved, my lord.
The respondent offered it to place the matter before the SL for of the proposal of the petition as per recommendation made by the TLC on 15/6/2020. It appears that by order dated 23rd 5/2025 the standing counsel for the elementary department, that Mr. B. David, learned government advocate, was directed to receive instruction as to what step the district elementary education officer corrections has taken for recommendation made by the district level committee in its meeting held on 15/6/2024. Today, it's open learned government advocate produced a letter dated 6/2025 issued by the district elementary education. And that the proposal of the DLC, the proposal of the petitioner for being appointed on completed ground has already been approved by the DLC in its meeting held on 15/6/2024. And the office has forwarded the same to the secretary of the doctor of the Department of School Elementary. White letter number K dash B from 2024 dash 25 struck off dot A double P double X 945 dated 9/2024. Order. Upon further submission, now the matter will be placed before the SL. The learned counsel for the petition submits that in view of the aforementioned instruction, so receive that for today. This petition may be closed by directing the respondent cooperative to place the matter before the SL. We are taking note of the submission of learned counsel for both the parties. Support this by directing the respondent cooperative to place the matter of the petitioner before the SLC. We fix the date
Within 3 months, you know.
within a period of. In terms of about this, leaving the party here, there. The instruction so produced before the court, the market shall be taken to the record.
Oblige, you know.
Left.
Negative. Lordship. In this case, petitioner is an assistant teacher of SK Dev High School, Lordship. And what happened, Lordship, in the year 2011, Lordship, when the process of provincialization starts, Lordship, the department started a reorganization of some classes, Lordship, class 1 to class 5, as Lordship, sorry, lower primary, and class 6 to class 8 as upper primary. Because of this reorganization, Lordship, the petitioner's service was not provincialized and left out, Lordship. And thereafter, Lordship, the Act of 2011 was struck down, and 2017 was Lordship came into force. Even after 2017 came into force, Lordship, the petitioner's case was not considered under this Act, Lordship. And similar set of people, Lordship, approached this honorable court, Lordship, where in this honorable court clearly stated that these people have a legal right to consider their case under the Act of 2017, Lordship. I have next, Lordship, page 46, Lordship, the order starts, Lordship, and the 11 paragraph is at page 47, paragraph 6, Lordship. Similar set of people, Lordship. According to the petitioners, as they were disadvantaged because of the reorganization that they have taken place in the year 2011, they have at least a legal right for their cases to be considered for provincialization under the Act of 2017. Lordship. And thereafter, Lordship, page 49, Lordship, and another similar person approached before this honorable court, Lordship, and wherein the honorable court directed the petitioner to file a fresh representation before the respondent number 1, Lordship, and also directed the respondent number 1 to consider his case, Lordship. A similar, Lordship, direction maybe I am saying for a similar direction, Lordship.
This may go at this stage, Your Lordship.
Lordship, I'm similar set of people, Lordship.
No,
After-
your lordship, let the notice may go, your lordship. Let the formal notice may go, your lordship.
Page 49, lordship,
No, your lordship.
everything is similar, lordship. Nothing is there. I am paying just to consider my representation, nothing
Your
else.
lordship. His representation is, your lordship, for regularization, your lordship. Provincialization, your
Yes.
lordship. So, your lordship, kindly formal notice may go. In the meantime, your lordship will obtain instruction, your lordship.
To dispose of the representation of why instructions are required?
And even lordship, in the group of cases, lordship, where also,
Have you?
Whether the order is similar or not, your lordship, we have to see, your lordship. And your lordship, for that, your lordship, today is for motion, your lordship, this matter is came, your lordship. Let the notice may go, your lordship, at this stage.
lordship,
If we can dispose of the petition today itself, why
Yes,
don't we other time?
lordship, kindly for a moment, page 50, lordship, my laminate pen page.
Let us do one thing, madam, you please go to the petition and also the order,
Yes,
and examine whether there is similarity or not. At 2 PM, we will take it up.
yes, lordship.
Monday, your lordship.
No, no, no.
Item 6 and 7.
May I please? Lordship, the petitioners here in your lordship are, this is the second round of litigation for them, your lordship. Initially, your lordship, they are all graduate degree holders, your lordship, along with a graduate degree in arts, your lordship. They have Hindi, Proveen as a one of the, your lordship, qualification, your lordship. Now, what has happened, your lordship? There is an advertisement, your lordship, in 2010, your lordship, and in that advertisement, your lordship, the qualification they have, your lordship, prescribed for upper primary school teachers, your lordship, Hindi teachers, your lordship, is that, your lordship, Hindi as a one of the subjects should be there in the graduation, your lordship. Now, going by that, your lordship, we are not.
No,
Eli-
Mr. Portak,
Hmm.
tell me what is the last date of filing application?
That, your
It's
lordship, already over. We have, your lordship, this honorable court allowed us to, your lordship, submit application. Your lordship will kindly come to page 34. During the earlier round of litigation, your lordship, we are allowed, your lordship.
Then I'll have to take instruction. Let it come on Wednesday, lordship. Nothing will happen till that, lordship. Wednesday or Tuesday. Or even Monday also, lordship. Monday, lordship.
Otherwise, your lordship, what has happened, your lordship? This honorable court, your lordship, we were allowed to participate in the selection process.
So, Mr. Portak, that is not the problem. The problem is that this order came to be passed when?
This was, your lordship, on 29/1/2024.
24.
24.
24. And after another 2 years, somebody will come and we will allow.
No, your lordship, this has been allowed, your lordship. We have been allowed to participate, your lordship. Your lordship will kindly see the page 36, your lordship.
And this is an advertisement of 2020, lordship.
2020.
By this time, I think that there's already been over. Let me take.
No,
it
no, process is continuing. I have made a statement, your lordship. Verification process is going on, your lordship, but we have not been called. That is our grievance, your lordship. We have been directed by this honorable court to submit application. We submitted our application, your lordship. Thereafter, your lordship, this honorable court hold that we are eligible, your lordship, that we for the post of upper primary Hindi teachers, your lordship. In view of what this honorable court has held, your lordship, this they have want to have, your lordship, called us for document verification, your lordship, but they have not called us for document verification. That is our grievance, your lordship. That's why there is a contempt application also, your lordship. We have filed, your lordship, connected case, your lordship. In the meanwhile, document verification process, your lordship, is over, but the result has not been declared. That is our grievance, your lordship. We are not seeking that we should be allowed to participate afresh. We have already submitted our application. Those are pending, your lordship. And during pendency of that proceeding, your lordship, the writ petition ultimately disposed of. Your lordship will find a large judgment that is at page 60, your lordship, but the relevant paragraphs, your lordship, 66 onwards, your lords.
They are only given whether their application is considered or not. Only that instruction I have to take on Monday, lordship mechanically.
Para 10, your lordship. Your lordship will find. Lords, let them take it, sir. Lords.
Yes.
Monday.
Oblige you. Lord.
Deeply obliged, your lord.
This one copy to go.
Hi, please, your lordship. Lordship petitioner was discharged lordship from service without hearing him, without.
Which year you have been?
Yes, lordship. Thereafter, lordship, petitioner was
In the year 2008.
lordship. I have explained the delay, lordship.
Today we are in 25.
Yes, lordship. But in the meantime, he approved this honorable court for payment of subsistence allowance, lordship. That was also given to him in the meantime, lordship. And regarding this delay, lordship, para number 8, lordship, I have explained why is this delay. And during this year, lordship, at least one chance of hearing him, because there was a proposal for transfer him from that school because there was some circumstances was not good for him to impart lesson, lordship. At least one chance of hearing, lordship. That can be otherwise from the discharge order. It is clear that there wasn't any hearing, there wasn't any departmental proceeding, nothing. Only he was discharged from service, lordship. At least one chance to present his case. That is the only prayer, lordship.
Where do you have explained it?
Lordship, para 8, page number 12, lordship. Initially, he was not.
Have you enclosed any document to substantiate that you were suffering from liver disease, renal disease?
No, it was in. I have annexed a medical certificate, lordship, page number 39. Diseases were on instruction. I have submitted, lordship, but there is a medical document, lordship, page number 39 is the typed copy.
Now that here it is written that he is now fit to join service. The doctor has written like.
No ailment has been mentioned.
No name has mentioned by that.
It was his instruction that he was suffering from. That is why I have.
Otherwise, no medical document.
In that case, I can file an additional affidavit. But regarding that diseases, lordship, he has on affidavit. He is saying that, lordship, he was suffering from these ailments. That is why some delay was.
There is any document. How to classify it? Discharge order was passed in the year 2008.
Lordship, he has submitted
There we are
representations,
expecting-
lordship. In the meantime, he has submitted representations also, lordship.
Let
And approach this honorable court also.
Art is as cannot to learned counsel for the petitioner. That also heard Mr. R.R. Kursik, learned nothing counsel for NC Hills.
My lord, I am for respondent number 4 only.
And for 1 and 2.
R.R. Kursik for respondent number 4.
1 and 2.
Is Peter for the number 1 and 2. 1 and 2.
Sritam, तुम्ही
In this petition under Article 226 of the petitioner has selected the discharge order dated 13/6/2008 2008 filed by the Director of NC outcome by which the petitioner was discharged from his service with immediate effect. It's cannot to learn and comment for the petitioner subsequent. The petitioner was appointed. As assistant teacher, certificate science in Deompra High School, the district of NC Hill. In the district of Deba also, certificate R square NC Hill, Assam. Then he joined in the same month. Thereafter, on 9/6/2004, the petitioner was served with a so-called notice by the respondent number 4 as to a regular dispute. And thereafter, the respondent number 4 has placed the petitioner under suspension with immediate effect. Thereafter, on 8/12/2004, the petitioner has submitted one representation to the respondent number 4. Thereafter, the respondent number 4 by letter dated 17/11/2005 stated the petitioner by transferring it to Lyasum High School in his own grade and scale of pay. And in the order of reinstatement, some punishment were also pulled upon him. But due to some unavoidable situation, the petitioner not attend the school in his new place of posting. Thereafter, the petitioner has filed. The petitioner has approved the respondent authority by praising his inability to attend high school at Lycham. To attend the school, attended duty at Lycham High School, and according to the Bradford Concord Panama. And thereafter on 19/7/2006, the respondent number wording regarding transfer of the petitioner to the vacant post at Gurapara High School, Satyendra Nagar, under correctional district. And while he was waiting for some time, the respondent number 4 had issued the termination order, discharge order. This cannot go further submits that the petitioner was suffering from ailments of liver and kidney, and therefore he could not attend his duty. And and when he becomes fit to resume his duty, he obtained a certificate from the doctor that approves the authority to allow him to resume his charge. But you are not allowed to resume his duty. Being aggrieved the petition of his court by filing the certain the right for a some topics. Cannot go next further consideration that is obviously so to the returnable in 4 weeks. However, no formal notice is required to be issued to the rest number 1 and 4, since they are represented by their standing counsel. However, step upon respondent number 3 be taken by registered post with ADN also by the process. This number 4 weeks.
Lordship, respondent number 3, my learned friend is saying that Mr. R.N. Das will appear for Principal Secretary to the Mahasa, but he's not. I have sub copy, but he's not there.
You text them.
I did, okay, registered. Deeply obliged.
Number 9.
May I please, Your Lordship? The petitioner hearing is a retired assistant teacher who was posted in Haji Maskandar Ali Lashkar School, Salsapra, Kachar. After his retirement, an amount of 4,48,907 was recovered from his DCRG. Hence this petition. Your Lordship will find it at page number 21.
Why the amount was recovered?
Not only written as as other assessed dues. And nothing else. In the PPO book also written only other assessed dues. But the petitioner herein has never taken any committed leave. There was no departmental inquiry, or if any assessed salaries was in a increment or extra was in, it is not his fault.
The amount was already deducted.
Yes, already deducted. Page number 21, Your Lordship will find it. It's the Treasury Officer's Kachat handwritten. A deduction was made on 5/2/25.
Treasury. Treasury.
PPO was issued by the Directorate of
Pension, yes, Lordship.
Anybody for Directorate of Pension?
Notice may go ahead. Notice may go ahead.
Artificial social learning. Learning something for the response number.
I am for respondent number 1 and 3.
For respondent number 1 and 3. Dashboard.
I am appearing for respondent number 4 and 6.
Number 4 and you only have 4?
2 and 7, Lordship.
2 and 7. The grievance may sought to be addressed in this petition.
The soft
Is
copy
that
will
the
be number
petitioner
two.
That's it. It's a reference. Adi Maskandar Ali Lashkar High School, Calcutta. Then after his retirement, retired on the 31/12/2020. Then after his retirement, PPO was pension payment order was issued by the Directorate of Pension, Director of Pension. Wherein the financial account officer of the Directorate of Pension has inserted a column whereby
Already hold on, no?
a recovery of a sum of rupees 4,47,900 as other excess
Assessed.
assessed
Oh,
or
wait, wait.
Assessed, A-double-S, E-double-S-E-D.
User indicated that the treasury officer Tasar is or like order date 2025 and deducted the aforementioned amount as other assessed dues from the total ECRT amount of approximately 90. Whereas the petitioner has received sum of rupees 10,700. 7,792 rupees. Yes, balance this year the amount. This year. The social learned counsel for the petitioner submitted that the pension payment order being annexed with the petition annexer number C. Nothing has been mentioned as to why the aforementioned amount has been deducted from the DCRT of the petitioner. DCRT amount of the petitioner. Be that as it may. Acknowledge this to the respondents for it.
6
More
months.
further copies the respondent. In the meantime, learned counsel for the number 3.
1 and 3.
1 and 3 says received instruction as to why the amount of rupees 4,48,927 was deducted from the total year of the petition list after 4 weeks.
Deeply obliged.
May I please, your lordship? In this case, the petitioner husband was a subject teacher at SP Higher Secondary School, Dhubri, who got retired 31/3/2010. After the retirement, he got medical treatment at Narayana Hospital, Bangalore. Thereafter, the husband of the petitioner submitted representation claiming reimbursement. After all the formalities, the respondent authority sanctioned amount 4,37,829 rupees. So sanction letter in the page number 31.
Yes, sir. Medical reimbursement. 6 hours. HUSC.
Lordship, after the sanction, the husband of the petitioner was died, then the fresh proposal already been submitted. Fresh proposal is in the page 34.
Now the matter is pending before the Director of Secretary Education.
Yes, Lord.
For re-sanction of the amount.
Yes, Lord.
Yes, so madam, you obtain instruction.
Yes, your lordship.
It is page number 37 of
30.
the petition.
34, your lordship.
No, 37.
16. It was submitted on 4/12/2024, Your Lordship. I would like to take instruction on this representation, Your Lordship.
Not representation, this is the letter of the inspector.
Forwarding proposal or proposal, proposal. Yes, Your Lordship, I would like to take the instruction.
Lordship, pendency shall not be a bar.
Third is that.
K alum.
And
6.
details that I discussing
Six.
for the respondent number.
I'm appearing for respondent 1, 2, 3.
1, 2, 3, and stop ready for.
Five.
Oh, 5. So for
Number
number 7.
Lordship, for six lordship, principal secretary has been made a party lordship. There is no principal secretary at the moment, lordship. There is commissioner and secretary lordship. So
I include Purvaria.
lordship, some correction because there is no principal secretary, lord.
It's the only here for respondent number 6.
Include Purvaria, otherwise your thing is going to be stuck. Remains so far that I include Purvaria.
It is petition under 6 of the.
Huh?
Yeah.
4 more no go. Private, Your Lordship, respondent number 4 is there, Your Lordship, has to take steps. The principal. It's a colon. I had a file for the to impede the party. To stop off.
Take the medical reimbursement, respect of the deceased husband of the petitioner.
Months of petition was the time. Immediate.
The husband of the petitioner was serving as subject service SP higher secondary school. And he retired on 31/6/2010. And after retirement, the husband of the petitioner got medical treatment at Narayana Bangalore with 192. And thereafter submitted a claim for medical reimbursement. And thereafter, the respondent offered is by letter dated 23rd to 2022 and an amount of 829 rupees only as medical reimbursement. After the death of her husband, but the same section of amount has not yet been paid to the petitioner without assigning any reason. And therefore, the petitioner approved this for by filing the present petition or issuing direction to the respondent of party. By issuing direction to the respondent to release the information. Where is the picture? The documents passed on the photo. To the respondent, return evidence for whether notice is required to be issued to the principal.
Yes, Your Lordship.
Right.
Because there is a line, Your Lordship, the said amount could not be drawn by the principal of SPH School Dhubri as directed by your letter under reference so and so before the demise of the petitioner of
But
the said school.
The amount has to be re-sanctioned by the director of secondary education. So,
The instruction to amount. I will obtain instruction from my side, Your Lordship, direct BSc. And Your Lordship, as the steps will be taken on behalf of a respondent for Your Lordship, private respondent. In the meantime, the notice should go, Your Lordship, to respondent number 4 also.
the notice is so to the respondent. Returnable and for our non-formal notice is required or 1, 5 and 6. and 7. They are represented by their ethics counsel. However, notice is issued to the respondent number 4 by registered post with alien automobile process. Further, necessary correction may be made with respect to the respondent number 6. By the learned counsel to the petition. It appears from the annexure 19 that the inspector of school BTC has already sent the proposal, the director of secretary requesting to take necessary steps for re-sanction the amount of rupees 4,37,829 rupees in favor of the petitioner, Mr.
নাম তো লিখে দিব।
Whitehall. Let transport of it say. Sir. And under such circumstances, it is provided that he does learn extending of the resident number. And number 2.
1, 2, and 3. Correct.
That's the present status of the aforementioned provision. Awarded by the inspector of the school by the letter dated 4/12/2024. Annexure 9. And it's list of the for it. It is made clear that annexure of this will not be a bar in releasing the aforementioned amount in favor of the petition.
I'm deeply obliged.
Highly obliged.
Right, lordship petitioner is will apply for dice court lordship in the year 2024-25 lordship. And see the lordship page number 25 lordship.
Is that already? The letter was written in the year 2024, a year back.
Yes, my lord. Subsequently, lordship, annexure 9 page 27 also, the executive director SSA directed to file it online. And in the representation dated annexure page 31, annexure 12. Also, here it is found that the petitioner has written to the executive director SSA stating that the district mission coordinator failed to upload. If that be so, lordship, then the best option without going into the why he failed to upload, he can reapply again on online, lordship. Only after online application, subject to verification and other things are all satisfactory, they will get the dice number. But it has to be on online application. And for previous year, he won't be getting it. Current year, he will be getting the dice code.
Why the previous year he could not get it?
Lordship, because it's a portal, lordship. It get closed on September 15, lordship. Thereafter, lordship, we can't rectify the if there is a defect or a non-allotment. and it is managed by the central government, the portal, Lordship.
Lordship, page number 28, Lordship. I am applying the deadline in the 24 October 2024, but my online application is not accepted.
It seems that there is some defect either in the application or in the online. So better, Lordship, if he applies it again, then only.
No, it's a totally if he again apply this year, then he will be losing 1 year.
But Lordship, it's the policy and we cannot rectify anything of the earlier year.
No, why?
And every year it has to be renewed. Every year it has to be renewed.
No, that's all right, but why it was not accepted?
And that Lordship information I have to take because
So you
either maybe.
have to take the information. You have. Third, Mr.
A. Islam.
Third and counsel for the. Petition under Article 226 of the petitioner has tried for direct correspondence to allow the unified district information system to educate the due diligence for in favor of the petition made by the district level redressal committee Baksa and consequently ordered date to 10/7/2024 issued by the district commissioner Baksa. The learned counsel for the petitioner submits that the petitioner is to the establishment with effect from 1/1/2000 to impart that we to the children of remote areas of Pakistan. And the state school open, obtaining permission, as well as departmental report. And the school was verified by the district committee. Those that concerned block delivery education officer and on receipt of verification report, the district committee Baksa has executed all the 11 documents. And on scrutiny, the of the petitioner is found to be eligible for due diligence and recommended for allotment of the due diligence. Thereafter, the district commissioner Baksa has approved and ordered it in 10/7/2024, recommending the school for allotment of due diligence for the year 2025. And forwarded the same to the director as a but till late no diaspora has been allotted. The learned counsel for the petitioner submits that by annexure 10 and page number 28 of the petition, the petitioner school has applied online for the UDI school. But the said application was not accepted by the respondent. SS. Accordingly, it was provided that Mr. Totally learned counsel for the SSS self-obtained necessary instruction as to why the application, online application of the petitioner was not accepted. Is the matter one covered? Eight of
Lordship, during the pendency of the petition shall not be filed for provincialization.
I fear that potential are allocating you guys for the petition.
My pleasure, also. The matter relates to compensation, compassionate appointment, Lordship. The second time petitioner is before your Lordship, and now this time the SLC has recommended his name. But his post was adjusted in grade 4 post in the district of Tinsukia Lordship, as there is no vacancy in the Lakhimpur district. Thereafter, Lordship, in persons of the letter issued by the Under Secretary, the Inspector of School Tinsukia district has submitted the format, Lordship, showing one vacancy is there in Solfua Hindi High School, and thereafter submitted the same before the Director, Lordship. And the Director also forwarded the said proposal to the government, but till then no action has been taken to appoint the petitioner in the said post, Lordship. The Annexure 6, page 48, Lordship. This is the proposal submitted by the Director before the government, Lordship. It was specifically mentioned that the petitioner is to be appointed on compassionate ground as per recommendation of the SLC, White Minor City 2323, Lordship. And this letter also received by the department secretary of the government of Western, Lordship, but till that no action has been taken.
I have to take instruction regarding the status of this matter.
Or next.
Peace, Oria.
Also, or
For all the respondents.
all that. The grievance of the petitioner is that its name or recommended by the district level scrutiny committee, Lakhimpur,
Yes, Lordship. Lakhimpur.
and also by the state level committee for being appointed.
Kindly see page number 33, Lordship. In serial number 14, petitioner name is there. It's 33.
In
First copy.
that post. That for
Yes, Lord.
And remand, sir.
and also recommended. No, and adjusted in that post under highest.
Tinsukia.
Highest Tinsukia. Yes, Tinsukia. On comparison with ground. On comparison with ground. In place of his father who was working as assistant teacher at Contempt Navaru ME School, who died in harness on 7/12. The learned counsel for the petitioner. Referring to the letter.
Annexure 5, page 40, Lordship. This is received by the Inspector of School Tinsukia District Circle.
Referring to Annexure 6. The letter of the director. Secretary Education to the Secretary of Dr. Osam. Has submitted the proposal of appointment of one number of therefore proceedings to be on completion job. By her letter dated 21/12/2023. But till date, no action has been taken by the Secretary to the Dr. Osam, Department of School Education, who appointed the picture. In view of the letter of the Director of Secondary Education dated 21/12. In view of above, it is provided that Mr. Sharma shall obtain necessary inspection in respect of the present status of the proposal ordered by the Director of Secondary Education by letter dated 21/12/2023, and insert 6 at page number 48. This is a list of matter on 17.
Lordship, before my learned friend start, I need some explanation in this case. Yesterday we have misplaced this item. Now I have gone through this case, Lordships. Here I have found that a similar cases has already been dismissed by the coordinate bench in batches of cases. So let it taken up on Monday. I'll produce those judgment also along with the this one, Lordship.
Similar set of.
Yes,
cases.
exactly similar case. Exactly, yes, it dismissed lawsuit in a basis of cases.
Dismissed.
Yes. I will produce that order, lawsuit can take it up on Monday, lawsuit.
Mr. A. Hussain, Garden for the system for the respondent.
Secondary education,
Elementary,
lawsuit,
elementary education.
in secondary education law.
Since the press for listening the matter on Monday, so as to enable him to order a decision of this court by the beds of the decision were dismissed. Which were similar to the present ones. There is according to law, the list the matter on Monday.
Oblige, your
Oblige. May I be the lawsuit? The case of the petitioner is there, lawsuit, the petitioner is a retired employee. During his service tour, he was suspended for 2 times. But next suspension was interfered by this court lordship. But his law, though the suspension order has been revoked, but the suspension period not yet regular. So he received a low amount of pension lawsuit. This is the case lawsuit. In this case, the petitioner approached the authority. The authority 32 is the communication from the Department of School Education to the BTC authority. They look into the matter lawsuit, but they have not done anything lawsuit.
Department side, they go to it, learn it for the sir. As for the.
That's one, 3, 4, and 5.
3, 4, and 5. It's the PEGO for.
Only one. Only one.
Only one.
One. That over for respondent part 2. Right for. Direct the respondent authority to release it unpaid supplementary allowance. The period of 49, 7, 9, 8, and 21. Second of March 2012. 28,014 and also to issue direction to the regularize the suspended video with back from the program. When review of the day and the third issue that the and also to direct it also prepare benefit and unpaid daily salaries for the aforementioned period. Heard the petition that's okay. That notice to the response regarding that for our no purpose notice will trigger to it. All the respondents are represented by their standing counsel. However, after check of the it's a matter after 4 weeks. Whether you have filed any representation for.
I have filed my representation in this case. Page 39. An extra 8.
So going further, what we know that why tenants are 8. The representation filed by the petitioner to the DI of school elementary education department. PTA Kupraza. That is 13/5/2025. To release the substantive allowance for the period appropriate and also the pensionary benefit and arrear salary. But the same will go get a response.
After that lawsuit, the school education undersecretary communicate to the BTC lawsuit. That is page 42. On the basis of the repeated offence. The BTC authority. On 35,025.
Do you have
Yes,
filed
they
the
send the matter
representative
because-
to PI of it?
Yes, madam. That's it.
But how they letter?
That's it. I send the letter to the all the director of elementary education BTD also. Next 41, page 41.
41 is the copy was sent to them,
Copy was
that's what
sent
they
to
have
the-
put
this is the-
all the copies. of it.
He had also said, you have done same to the current secretary.
To the principal secretary, to the director of elementary education BTD.
Principal secretary, and the director of the and on the basis of the said presentation, the undersecretary to the doctor of the department of the legal by connector type that is the purpose. Requested the director of ETC to present to take him a group into the matter and take necessary action from his end.
Okay.
But the same failed to invoke any response. And under such circumstances, it is provided that Mr. Bora learned of BTC shall receive instruction about the status of the representation filed by the petition on 13/5/2021. Place the matter on.
Problem.
Obligations.
Wait. Possible for time being, but conducting council is late input number 1, can be, and possible for time being.
Challenging the transfer order.
Pardon?
Challenging the transfer order. to the petition.
No.
Transfer from which platform?
Lordship. The order is at page 61.
Conducting council is late input number 1, my lord. He will do this case, my lord. Kindly pass on for time. But it's always.
May please order. Kindly pass over a meter for time being, lordship. 60. Okay.
Maybe, madam, these are pardon matter earlier, but I received a letter madam, from the respondent said, madam, the respondent said submitted a report on a previous date, madam. Foreign malot, they have malot clearly stated malot in para 5 of their report, malot. The government has taken a policy decision to taken a policy to grant retrospective benefit to newly provincialized grade 4 employee of 755 number of middle school similar situated grade 4 together in the first phase. So, malot, this is the malot policy decision of the government to grant the retrospective benefit to the 755 number of grade 4 employees of the middle primary, malot, ME school, malot. 15, I think 15, 7. So, malot, what happens? Since 2013, malot, since the government took the decision to grant the retrospective benefit, because in the first phase, total 500 number of middle school were provincialized, containing both teaching and non-teaching posts. Subsequently, malot, in 1996, malot, 755 number of middle school were provincialized, but only the teaching posts were provincialized, but non-teaching posts were not provincialized. And at the same time, malot, the 755 number of teaching posts, which were provincialized in 1996, they were given the benefit from 1991, from the first phase, malot. In the first phase, 500 number of schools were provincialized for teaching and non-teaching posts. In 1996, 755 number of only teaching posts were provincialized, but the benefit was given from 1991. Now, subsequently, my lord,
non-teaching post for those 755 number of middle school, my lord, were provincialized, and the government took the decisions that those grade 4 employees of those 755 number of schools, they are also entitled for the retrospective benefit, and accordingly government took the decision, my lord. Since 2013, my lord, government issuing the letter to the director and director issuing the letter to the concerned deputy commissioners and the DO to submit the consolidated reports of all the grade 4 employees working under their respective district, my lord. But what happened since 2013, now it is 25, my lord, almost 13, 14 years, my lord. All the deputy commissioners, they are not collectively sending the consolidated reports to the government, and the government is also not taking the final decision, my lord. So what happened here, my lord, the petitioners are from the Dhobi districts. So in Dhobi district, total 43 number of middle school were provincialized, and total 43 number of, my lord, grade 4 posts are the grade 4 employee, they are claiming the benefit now, my lord. Here total 25 number of petitioners, they are before your lordship. Now what is happening here, my lord? Then the government took the policy decisions. Subsequently also a meeting was held, lordship, earlier, my lord, page number 100 of my petition, my lord. Lordship, if I'm correct, my lord. Yes, 99, my lord. Page number. Lordship, this is the instruction which I received, my lord. I'm seeking accommodation, my lord, today, my lord. My lord, page number 100. This is the, my lord, resolution of the government. There is a resolution, my lord, adopted by the, my lord, a committee, my lord, under the chairmanship of the secretary to the government of Assam Elementary Education Department. And by this resolution, my lord, government took the decisions for granting the retrospective benefit to those 755 number of grade 4 employees. But these decisions, my lord, has not yet been implemented. Now the petitioners are before your lordship, my lord, before this honorable court, seeking implementation of that decision, my lord. And the government, my lord, on the director of elementary education, my lord, on the previous date submitted a report, my lord, and from this report also, my lord, they are also, my lord, stating the same thing, saying the same thing, my lord.
Lordship, in this matter, Mr. P.N. Sharma is appearing, and my lord, today, due to my lord, personal difficulty, he was not available today, my lord. My lord, in this matter, I have received my instruction, my lord. Already there is a process going on regarding the with the authorities in the district, my lord. So, my lord, some accommodation is given is needed today, my lord. 2 weeks time may be given, my lord, and accordingly, my lord, on that day, my lord, we'll be able to, because otherwise, my lord, it will be futile today. He's submitting today unnecessary documents. Let the report come, my lord, then we'll see, my lord.
Well, otherwise, my lord, this court also can issue a read, my lord, directing the government to implement the decision, my lord, district-wise. If the decision is implemented district-wise, my lord, the problem will not happen, my lord.
My lord, not required.
Otherwise, since
first the report should come, my lord.
Since 2013, director, my lord, writing the letter to the concerned district, my lord. But the districts, my lord, they are not cooperating and they are
My
not
lord,
sending the.
it takes time, my lord. These things take time, my lord. My lord, there are many districts, my lord. 36 districts total. Which is
This is the problem, my lord.
So, my lord,
otherwise, if the decision is implemented,
cannot, my lord, a blanket order cannot be passed, my lord. It will hamper the whole process, my lord. So, my lord, some time may be given, 2 weeks. Till then, my lord, let my Mr. Sharma, my lord, also appear, my lord. He's been handling this case from the beginning, my lord. He will be able to appraise the court properly.
All right. On 38/7/2025, you have 41 letter before this court. And they will show you 41 letter before this court. Stating the same thing.
Same, my lord. Because, my lord, it takes time, my lord. These things take time, my lord. My lord, some time may be given. Mr. Sharma also will appear today. We are handicapped because he's not here, my lord. He's well versed with the case, my lord. So, my lord will accommodate us today, my lord. I'm handicapped also, my lord.
Oh, sure.
My instructions are that, my
I'm
lord.
not.
I've given it, my lord.
You will come with the same here.
My lord, I'm not objecting to the adjournment period, but the only issue is, my lord, whether the, my lord, court can issue the writ. Ultimately, the court can issue the writ, my lord, to implement the decision district-wise, my lord. This is the submission. Otherwise, adjournment period, on adjournment period, I have no objection, my lord. But only the issue is, my lord, since 2013, government is also supporting our claim, my lord. The only problem is all the districts.
Now, in respect of which district you have received the proposal?
My lord, actually, that is why, my lord, Mr. Sharma is there, my lord. I'm appearing on his behalf, my lord. So,
Partial Islam garden. Method is being looked after by a third or it- and if some parts of not present in the portfolio, and that's some also enable updated extraction. That is accordingly allowed with the method on
well, 7 inches. Deeply obliged. Obliged. Did you know? Yun ang pwede dun sa mga control sa rumah. Decision is still awaiting, my lord. Decision is still awaiting, my lord.
Same instruction, my lord, consistently same instruction, my lord.
Beginning the highest level will be to.
Yeah, that is one reason.
higher authority means
I'm not sure, my lord. They have mentioned like higher authority. Maybe at ministerial level, my lord. Because file was returned back from finance department. That I have already placed before this honorable court earlier occasion, my lord.
what was the direction of the finance department? Of the finance.
Finance department relegated the matter to the administrative department to take a decision, my lord.
When the file was sent to the higher authority.
That, of course, my lord,
What one?
not mentioned.
Not because-
That e-file number was given in the communication, my lord, but when it was submitted to the higher authority, that has not been mentioned in the communication, my lord.
Cannot say who is the higher authority also when the file was sent.
In fact, I admit that the instruction is not very clear, my lord.
Can we conduct the case this way?
Sorry, my lord.
Can we conduct the case in this way?
This one is specifically component.
Lordship, this has been.
Or
going
else,
on
my lord may decide
on and
matter
on,
on
your
merits, my lord. But only difficulty in our part, my lord, we have not filed any opposition in this matter. This matter was under consideration of the government. We have not filed any response.
Lordships may direct them to take a call, your lordship, by fixing and date, your lordship. That's my prayer is. Let them take a call, your lordship. Unless there is a direction from this honorable court, your lordship, they are not going to take any decision, your lordship. They will go on taking time again and again, your lordship. There is a specific direction from this honorable court 4 times, your lordship. Your lordship is magnanimous, your lordship. They have taken a decision, your lordship, to pay us, your lordship, equivalent to the regular employees, your lordship, then they are not paying us. And they are processing the file, your lordship, again and again, your lordship. Your lordship has seen, your lordship, from this table to that table, your lordship, it's going on this department to that department. Your lordship may direct them to consider the matter and take a call within a specific period of time, as this honorable court may be pleased to fix, your lordship. Rather than keeping the matter here, your lordship. Your lordship has seen, your lordship, it was a matter of 2022, your lordship. No affidavit is in file, your lordship, till 2025.
The problem is that their status is now not clear.
Lordship.
Whether they are going to give in or not going to give in.
Lordship. That is why, your lordship,
File an affidavit. We will grant you 1 week time. You file a short affidavit indicating your state. Thereafter, we'll finally take it on.
Lordship.
Well, I'm praying for a little bit more time, at least 2 weeks time.
Lordship.
Problem is that after 2 weeks, another council will come and.
Well, in fact, in this matter, continuously I'm appearing. Well, it's not that case that some other council is representing the matter. Well, fix a date.
No hard. The response implemented it hard. There is a part of SSN.
SSM. SSM is for now 4 months.
You for
Respondent number 5, you know.
respondent number 5. The course of deliberation, Mr. Attorney has produced a letter. Sent by Deputy Secretary to the Governor of Court. Addressing the department stating that the department has endorsed the method to higher authority by E5 number 5832 2009. And that was a clear instruction the higher authority the department that further process of a fair perusal of the letter indicates that there is no indication in the letter as to who is the higher authority and when the file was endorsed. And when a query was put to Mr. Catonier, he also put out apprise this court as to who is the higher authority and when the file was transferred. Under such circumstances, it is provided that Mr. Catonier shall file a court affidavit indicating the strength of the department.
Within 10 days, your lordship.
Within 10 days. This is the matter of 19 September. The letter produced for the court today shall be marked as the answer A and shall be part of the.
Oblige.
Oblige, your lordship.
Yeah, please, Lordship. Lordship, there is the last order. Lordship.
It says today we have filed affidavit filing.
You have filed.
My lord.
Part means
J after.
after the next one.
Lordship, next week, any date, Lordship, non-payment of salary, next week, any date. Next week, Lordship, any date.
Also hard. Yeah. Lord, something folks for the responder elementary something part. Person who ordered it at 22/8/2025. She is quite affidavit of position today morning. And as such, it tries for this thing to matter after a week. There is a lot of the matter. What the matter?
What the matter?
What the
May I please Lordship, my lord? My lord, this is a very clear case, my lord, where the petitioner's name was reflected in the Dias code pertaining to the year 2009, my lord, which is a mandatory criteria, my lord. And the concerned, my lord, department was given 1 week time as a last chance to file their affidavit, but we have not received any affidavit in the period. And regarding the stand, my lord, my stand, that is also, my lord, supported by the version of the respondent number 5, who happens to be the headmistress of the school, my lord. For a moment, my lord, will kindly come to my lord, page number, my lord.
was here, spoken.
Miss Fukan was there. My lord. Earlier,
My lord, here I am appearing, my lord. My lord, here department stand is that his name is not recommended by the district scrutiny committee.
that is there.
District scrutiny committee has not recommended his name, my lord. So
Do you have affidavit?
not yet.
Why? There is a correction.
Yes, my lord. My lord, kindly grant 2 weeks time.
Why please?
My lord, today I have been appearing.
And tomorrow another
My lord.
another advocate will appear and he will pay another 3 weeks or 2 weeks.
My lord, I'll assure.
So how about learn it? Certain learn it. The next concept for the respondent number 1 and 2. And you
I'm for respondent 6 million.
check your good name.
B. Rahman.
B. Rahman.
I am appearing for 1 and 2.
And anybody for other respondent?
Lordship, H. Borough for content number 2.
H. Bora.
Or Borough.
Bora for respondent number.
No, Lordship, S.
It's a play to learn it from the respondent number of the
1
So there is
Time going on the TV.
No, I'm technical level bad again.
2 weeks. 2 weeks to think.
How about one side time is granted to start to file affidavit?
But she will kindly fix it on 10th, my lord. 10th of September.
That's the list the matter on.
My lord. Deeply. Given the last chance to. But she will kindly observe it. Yes, so further chance should be given to them. I'm deeply obliged.
May it please the lordship. Lordship, here in this matter, lordship, we have already filed our affidavits.
The pleading is complete, lordship.
Pleading is complete and similar matters are also pending before this court. So, lordship, all those matter may be taken together, lordship. They are writ petition number 8387 of 22 and lordship 8447 of 22, along with this matter, lordship.
You give the number to the court.
Yes, lordship.
Lordship, records probably have been received by.
Yes, lordship, records are also there.
So considering some sort of urgency in the matter, lordship, can it be taken in the next week, lordship? On next Thursday.
Lordship.
How do we before vacation? lordship?
Yes, before vacation, any date, lord.
19. Lordship, can it be on 18th, lordship? 19 is motion day, probably. 18. It will admission of the. Yeah. Last week motion. 18.
Submitted in the part. Athletic have already been mentioned by the parties. And the matter is relative to admission hearing. And similar matter will be
WPC 8387 of 2022.
and
and 8447 of 2022.
And this matter may be taken along with those matters for admission hearing. According to this provided that basis of this matter of
18th lordship, I think 19th is the motion day, so it will be difficult. Because in motion day for disposal.
No.
Because the disposal is required in this case, lordship. Because for last 22, this matter is lingering, lordship. Because 18th, I think the hearing day will be better, I think, because in the motion day, the matters will be there.
let it be on motion day. 19.
Highly
Right,
obliged.
right.
So take this matter along.
May it please your lordship. In this case, I am claiming a pay parity with my juniors who have still the march over me in terms of pay, your lordship. In spite of I being equally situated in terms of education and everything, and I've obtained the PhD and other relevant degrees prior to them. And in spite of that, they are, although the person is retired, your lordship, by now. So
I
there
am
was a
seeking little accommodation to them, my lord, for, because as per last order, my lord, of this honorable court, although we have filed one affidavit through the director of higher education, my lord, this honorable court has asked to file one affidavit by the secretary, my lord, for which I have not received any instruction till now, my lord. So, my lord, may
That is
kindly
a
give
long
me-
story, your lordship. They have not been filing. So some strict direction may be given so that they file, your lordship. Otherwise, the case is languishing. These peoples have retired by now, your lordship, therefore. And again, the 8th pay commission is coming. Therefore, it will be difficult, your lordship, in that case, if the petition is decided either way. So let them, I have no objection to taking time, but let them file. There should be a direction that they should file it by next week, on the next date.
may kindly 2 weeks
Otherwise, also without the affidavit, the hearing cannot be undertaken, your lordship.
When the direction was issued to file affidavit by the secretary,
It is on the
Your lordship will
April,
kindly,
April, my lord.
27/11/2024, your lordship.
Ninth 9th of April, I guess, my lord.
Prior to that, the director has filed it, your lordship. But the director affidavit is neither here nor there. Because the rejection was made at the behest of the government.
okay, sir, our same number. Yes, sir.
Yes, my lord.
You,
Ms. Esnath, on behalf of Dr. P. Agarwal, Standing Council UGC.
no, sir. Okay, yeah, but,
5, my lord. She's appearing for 5.
Dr. P. Agarwal,
Yes, sir.
UGC,
Yes, sir.
and you. And
For response number 7.
that's
And
the
the
number
response.
7. Mr. Gogo is there?
Respondent 5, my lord. You file the affidavit.
Gogo for number 5. Sir, as the subset, it be granted some time to file affidavit. File an affidavit.
On
File
behalf
a
of secretary.
number,
1 and 2, your lordship.
respondent number
1
1.
and
That is accordingly allowed. This the matter. After vacation. After on the vacation. So as to enable Mr. Das to file the affidavit. Is that clear that no further sound to be granted to Mr. Das to file it.
Your lordship will direct in that case that if the affidavit is not filed, the secretary will, otherwise they'll not file it, your lordship. Has been
In the event of failing to file the affidavit that day, the court will proceed to hear the report of the matter without the affidavit of the.
I'm deeply obliged, Your Lordship.
May please your lordship. Lordship, in this matter, I am appearing for respondent number 6, 7, and 8, and we are seeking some time to file the affidavit. The affidavit is ready, lordship, but some signatures and some documents are yet to be received from the party. So
My-
lordship may give us
My lord, I
some
have an
time.
objection because my lord, they are delaying the process. Lordship may kindly see Lojima order dated 6/5/2025, my lord. That notice was received on my lord 8/3/2025. Thereafter, on 9/5/2025, they have taken time, my lord, for filing affidavit. Next, my lord, on 14/8/2025, also taken time. My lord.
Lordship,
And
the respondent.
after repeated call, my lord, the department has filed the affidavit, my lord, or one additional affidavit. They have taken the stand, my lord. But this respondent, my lord, due to vested interest, my lord, taking time again and again. Matter related to, my lord, the removal of the precedent, my lord, which was removed by illegally without following, my lord, due process of law, my lord. Rule 13 is violated, my lord. And thereafter, my lord, delaying the matter, my lord.
Lordship, the response.
14/8/25.
Yes, Lord.
You have
Lordship,
been granted 2 weeks time.
Lordship, the affidavit is ready, but the respondent lives in Borpeta and he has not been able to come to Guwahati due to some difficulties.
Okay, we are granting you time, but you have to pay some cost.
Lordship,
Sir, do you think learned counsel? Sir,
G Das,
learned counsel for the respondent number
7, 8, 6, 7, and 8.
6, 7, and 8. Then Mr. Talukdar for
My lord, for elementary education, my lord, 1, 2, 3, 1, 2, 4, and 5.
number 1
4 and 5.
and 5. And spoken for
Respondent number 3.
respondent number 3. Mr. Das learned counsel for the respondent number 6, 7, and 8. Submits that he may be granted some time to file the affidavit. And though the affidavit is ready, the respondent could not come and sign the same, for which he could not file the affidavit in time. There is according to the law, subject however to payment of cost of rupees 5,000, which shall be deposited before the in the welfare fund of the Guwahati High Court Employees Association. Before next day. Please done.
My lord. Thank you.
Obligation.
Obliged.
Please, your lordship. Lordship may kindly peruse the order dated 23/10/2024. Paragraph 3, lordship. 4. 3906 WPC.
Order dated
Order dated lordship 23/10/2024.
yes.
Fourth paragraph, lordship. The director of elementary education, lordship got it.
Yes.
Director of Elementary Education, Assam, who is also personally present in the court, submits that the petitioner was performing his duties as assistant teacher of Thoramuk ME School, Bulaga till 28/2/2006. And accordingly, he was rightly paid his salary for the period with effect from so to 28/2/2006. However, on the basis of the communication dated 4/4/2003, written by the District Elementary Education Officer, Bulaga, wherein it was wrongly stated that the petitioner has been found to be absent in duty, which was from 1/2/2003. This court has passed the order dated 3/10/2024. He, however, submits that on the basis of the inquiry, it was found that the petitioner was found serving till 28/2/2006. Now, the period of absence, lordship, in their affidavit at page 35. Page 35, lordship. Their affidavit. They have filed affidavit in 3906. Page 35, lordship. Lordship, I am going to the findings. Findings. F, lordship.
Let's got it. Yeah. Sri Dilip Kumar Sharma was untraced during the period and attained the age of superannuation on 36/2014, as revealed from the report of the DEO Gulaga. Since the teacher concerned was missing and departmental proceeding was not finalized, therefore Deputy Inspector of School concerned did not take initiative for onward submission of pension proposal of Sri Dilip Kumar Sharma. Later on, the then DEO Gulaga submitted pension proposal in respect of the petitioner to the Office of the Director of Pension Assam by proposal dated 31/10/2019 and again on 2021, but the Director of Pension could not finalize the pension proposal due to insufficient documentary updation as well as non-submission of relevant information. As reported, due to non-finalization of departmental proceeding, the initiation of the provisional pension could not initiate by the DEO Gulaga. In next is 35A. In pursuance of the Honorable Guwahati High Court order dated 3/10/2024, passed in WPC 3906/2024, a hearing was conducted on 15/10/2024 in the Directorate of Elementary Education Assam for this purpose. A hearing notice was issued in the name of the petitioner by notice dated so and so, but the same could not be delivered to the petitioner as he was not available in his residence. It is learned from para 14 of the writ petition bearing 4006/2024 filed by Sri Dilip Kumar Sharma that a case has been registered against him, which is numbered as Hatigam PS case number so and so under section 376 IPC, read with section 6 of the POCSO Act, and at present he is behind the bar. As such, he could not be, he was found absent on the date of hearing, that is 15/10/2024. Now, Lordship, conclusion number 5. Conclusion 4. I'm reading 4 and 5 and 6. The period of suspension in respect of the petitioner with effect from 17/9/2006 to 6/3/2007 is hereby regularized and shall be treated as on duty. The period of unauthorized absence in respect of the petitioner with effect from 1/3/2006 to 16/9/2006 shall be considered as breach period for pensionary benefit only. They should regularize me up to 2014 for pensionary benefit, not for payment of arrear salary, for pensionary benefit. And so far 17/9/2006 and 6/3/2007 is concerned, they are regularized. But they have not regularized it till 2014, 16 date of superannuation, Lordship. District Elementary Education Officer Gulagat is hereby directed to take urgent appropriate steps towards granting of provisional pension in respect of Sri Dilip Kumar Sharma after completing all due procedure as per rule in force. But till date, no provisional pension has also been given, Lord. Till date, no provisional pension. I retired on 2024 or 2014, and that period from 2006 after 6/3/2007. From 7/3/2007 to 2014, that period is required to be regularized for the purpose of pensionary benefit. Otherwise, there will be gap in service, and therefore, the director of pension may not be in a position to finalize the pension lawsuit. That period should be regularized only for the purpose of pensionary benefit. Now, page 39 of their affidavit, Lordship, and actual.
So, you see, from the conclusion number 3,
Lordship.
the said period is treated as unauthorized absence and the principle of
Yes.
for no pay was applied.
Yes. The period with effect from 7/3/2007 to the date of superannuation, that is 36/2014, shall be considered as a period of unauthorized absence in service in respect of the petitioner. That period, Lordship, is to be regularized for the purpose of pensionary benefit, not for payment of arrear salary, Lordship. Only for the purpose of pensionary benefit.
Yes, Mr. Talukar.
My lord, he has not paid for arrear salary, my lord. He is paid for only pension, my lord. If your lordship take up the 3906/2024 fair person, my lord.
But he has not been paid for salary. he has been applying for regularization of that period only for the purpose of.
My lord, because
3906
in I-
subsistence allowance.
in conclusion number 3, my lord, the period with effect from 2002 that his superannuation for shall be considered a period of unauthorized absence in service in respect of petitioner is to be mentioned that she Dilip Kumar Sharma failed to respond to so cause notice issued to the authority concerned and the daily newspaper publication. Hence, he is not entitled to any salary and other financial benefits, including pension on the basis of principle no work, no pay, my lord. Conclusion number 3, my lord. Particularly stated, my lord. Because he was unauthorized absent, my lord, and at that point of time, my lord. Subsequently regularized for the pensionable.
The authorities have the power to regularize that period roughly. They have the power. For the purpose of pensionary
Sir,
benefit.
Doctor,
My lord.
to come to the conclusion number 3. For the period 7/3/2007 to the date of his superannuation of 38/6/2014. Date number 35A of your affidavit.
My lord. Conclusion number, my lord.
3.
3. Hmm.
You have not been paid this.
No, no.
Along.
One and not yet, Lordship.
From 16/9.
17/9/2006 to 3/2007. No, Lordship.
14.
My lord, kindly peruse the last order. My lord, he is behind the bar and his signature is not allowed to signature the paper, my lord, by the jailer. That's why last occasion your this honorable court directed government advocate to ensure whether he is. My lord, kindly peruse the last order, my lord.
That already been allowed, and I have signed my pension papers and were sent to the director of pension.
Director of pension. Then pension will apply.
And pension papers were already request it was submitted. But due to some reason, Lordship, technical reason, Lordship, that was not finalized. Subsequently, all the papers, including the service book, have been placed before the director of the pension.
Suspension was revoked on 6/3/2006.
Not yet, not revoked. Till I went to superannuation, that period, till that period, the suspension order remained. No review of the suspension, nothing, no substitution allowance was paid. And now, after filing of this 3906 petition for substitution allowance, they have paid 80,000, 83,000 substitution allowance. And their calculation is wrong, Lordship. Therefore, Lordship may direct the respondent authorities to calculate afresh.
That is another cause of action, my lord. If calculation is wrong, then how can it? বেলেগ রিকুইটেশন ভাবে যদি ক্যালকুলেশন রং বলে
I was placed on the suspension from 16/9/2006 to till my
You retired on
36/2014.
38/6/2014. Then what happened about your suspension order that has been revoked or
No, it remained.
Whether
Up to
departmental proceeding or disciplinary.
proceedings, so cause notice was sent to me since I was mentally retarded person. Therefore, I came to Guwahati for treatment. Therefore, the so cause notice could not be served upon me, Lord. Therefore, I did not appear in the proceeding. Now, after I got cured from my mental disturbance, then only I came to know that my suspension was not revoked, neither I have been given the pension nor the subsidy allowance. Then I applied, Lord. Thereafter, the one false FIR was lost, and I was put behind the bar. Now I have been convicted for life. I'm a person of 78 years old. And my family is under severe hardship. So let them calculate the subsidy allowance. And so far as the pension is concerned, Lordship, that pension WBC 4006, here I have played in my prayer, Lordship will find that page 15, sorry, Lordship, 14, Lordship 4006, WBC. 4006, this is for pension. And I have prayed for regularization of the suspension period with effect from 16/9/2006 to 36/2014, and thereafter finalize the pension and other retirement benefits, including area pension. I'm not paying for salary for that period.
Here you have only paid for subsistence allowance.
Yes,
for the
in-
period 16/9.
Yes.
38/6.
Yes, Lord.
But you have not challenged your suspension order here.
Suspension order, since I have retired, Lordship, question of suspension order, challenging the suspension order. doesn't- However, I had made statement that it was not reviewed.
Where is the suspension order?
Suspension order, Lordship.
Sir, Talukdar, you have filed your affidavit.
Page 14.
Yes, my lord.
Page 14, Lordship.
We have filed in 3906, my lord.
Order dated 16/9/06, Lordship. 14, page number 14, pending drawal of departmental proceedings, Sri Dilip Kumar Sharma, Assistant Teacher, Tamil ME School, is hereby placed under suspension as per order of the Honorable Minister of Education. Please, Lordship, as per the order of Honorable Minister of Education, Assam, by letter number so-and-so dated 1st September 2006, on the basis of the inquiry report of the Inspector of School, GDC Kolagar, by letter dated so-and-so, with immediate effect.
ঠিকানা দিলে কি? লাইফ লাইফ ইমপ্রিজনমেন্ট একটু রেডি করো না অ্যাপিল করো না
জেলাও করেছেন, জেলা My representation at page 16, dated 12/4/2023. Paragraph 13 of my petition, I have stated that proper calculation regarding proper calculation.
পেঞ্চন প্ৰপ'জেলটো ছাবমিট কৰা হৈছে আৰু ডিপাৰ্টমেণ্টৰ পৰা পেঞ্চন ডিপাৰ্টমেণ্টত পেঞ্চন ডিপাৰ্টমেণ্টে দিয়ে নাই প্ৰপ'জেল ছাবমিট কৰিছে proper instruction দিব
Oh, you have received the provisional pension.
Provisional pension not due. Not yet present. Substantial allowance of rupees 83,000 has been received by me.
For the period,
For the period lordship they have told. For the period lordship. 7/3 to as per instruction received by him, the lordship order dated 18/7/2025, lordship.
order dated
Order dated 18/7/2025, passed by this honorable court. Oh. From the date of suspension, lordship, till 7/3/2007, I have received 83,041.
Where is that letter?
That letter is with my learned friend.
Sir. Sir,
my lord.
where is the letter?
Okay, right now I don't have my lord. And
And that was also made a part of record law, that letter. If I am not wrong. that-
কেতিয়া দিছিলে মোৰ লাষ্ট লেটাৰখন আছে 30 November 24 বেংক ডিটেইলছটো দিব পৰা নাই কাৰণে ভেৰিয়া চেলাৰী দিব
the collector,
My lord,
you produce the file relating to his departmental proceeding.
my lord.
We'll see when you have revoked his suspension or not. So in the conclusion, you have mentioned that the order dated in the October 24. The suspension period is shown as
Yes,
1/3/2006 till 16/9/2006. But if you have not revoked the suspension order, how can you calculate it?
yes.
Mr. Arthur Larned and also our Mr. P. Dalkar Larned
Elementary duties.
for respondent number.
Respondent number, my lord.
Is open for respondent number
3. 3.
3. Respondent number 3.
1 and 2. 1, 2, 4 and 5.
In view of the submission advanced by Mr. Board that the petitioner was placed suspension on
16/9/2006.
and the said suspension was never revoked till his superannuation on
36/2014.
36/2014. And as such, he is entitled to subsistence allowance for the aforementioned period, but the authorities have released only the sum of rupees 80,000.
83,041.
83,041 rupees being the subsistence allowance. Subsistence. Under such circumstances, perusal of the file regarding the initiation of departmental proceedings against the marriage company. And accordingly, it is provided that the collector learning something of authorities shall produce the file, certain file before it's got on.
What if that page 36 of their affidavit, lordship, that conclusion number 3, that area salary may be kindly be directly to be paid, Lord. Because they have stated the period which have from 7/3/2007 to 36/2014 is the date of superannuation may be considered as, 36, Lord, 36. 36, the petitioner Sri Dilip Kumar Sharma is entitled to arrear salary and other financial benefits for the period with effect from 17/9/2006 to 6/3/2007. That may be, there, lordship will direct them to pay this amount, that arrear salary.
Let file be produced. Thereafter, we will finally dispose of the matter.
My lord.
The date we can oblige, Lord.
Yes, Mr. Thor, what is the pair in petition number 29?
Where is for payment of pension and other retirement benefits, lordship.
Okay.
Your lordship, here already, your lordship, additional affidavit has filed, your lordship.
Who have filed?
On behalf of respondent number 2, one additional affidavit in opposition filed, your lordship. For releasing of arrear salary, your lordship. I'm stating, relying your lordship on paragraph number 3, that is page 139.
No.
Last,
In the
last.
order dated 4/8/2025, there was a direction to you
Hmm.
to file an affidavit clearly giving reason as to why
That
you
your
want
lordship,
to revisit the speaking order.
yes, your lordship, that
Where
is,
that affidavit.
that is what your lordship, I am stating, your lordship, that is on 138 onwards, your lordship, we have filed our affidavit.
When
It was showing in my 1/8/2025.
order was dated 4/8/2025.
The only issue is that earlier,
Direction to have filed your affidavit. What is this?
your lordship, only here my prayer is that to revisit the file, your lordship, already 2 affidavit has already been filed, your lordship. And again, your lordship, here I am stating that earlier DSC has not gone through the records. And before being, your lordship, not gone through the records, she made one mistake, your lordship. And after this case was filed, your lordship, after going through carefully, examine the records, some serious facts of the
No. Therefore, you have been asked to file affidavit.
already 2
No. This order has directed you. By this order, you have been directed to file the affidavit. You filed the affidavit.
Yes, your lordship.
Third name,
Your name.
N.O. Kumar.
learned counsel, appearing on behalf of
K. Devi. K. Devi.
K. Devi, learned counsel for the just learned counsel for the secondary education department. This Peter submits that. So there was a direction in the order dated 4/8/2025 for filing an affidavit, giving the reason as to why they would like to revisit the speaking order. Yet the said affidavit has not yet been filed and request for granting some time period now place the matter on.
After 2 weeks, any date may be given. Yes, your lordship. Deeply obliged.
Look, the petitioner in this case was the principal of Assam Engineering College. He is now under suspension for almost 2 years. This is only challenging the suspension order, my lord. The disciplinary proceedings is going on. So we have challenged the suspension order, my lord. Initially, my lord, there was an order in 2023 that he will be on compulsory leave. That order was set aside by this honorable court, my lord. And once that order was set aside by this honorable court, then they issued a fresh inquiry and then they again suspended. So that's second round, because the first round of compulsory leave and the BP was separate, that was challenged. This is the second round, my lord. Now, my lord, my grounds are very limited, my lord. I will just note down, my lord. Allegations are of 2017. He has been suspended in 2024 after 7 years. That is the first ground, my lord. I will just narrate the few points, my lord, on which basis I am. Second is the initial suspension and subsequent extension are non-speaking orders. Initially, when we were suspended in October 2024, second round, my lord, which is the impugned order here, without any speaking order. And subsequently also, my lord, because every 3 months, as per their own guidelines and the Supreme Court judgment, they have to review it every 3 months. So every 3 months, my lord, it's a copy paste. I will show those documents. It's simply copy paste. There's no application of mine. Thirdly, my lord, the review conducted after 3 months period, and even the review, my lord, which was done by the department of the suspension, was not done within 3 months. Once I file an IA saying that the review was not done within the 90 days period of 3 months, what they do, they file a additional affidavit and they annex certain documents saying, no, we have reviewed. Those review meetings and the communication that this review meeting has decided to extend was never communicated to me. In July, they are saying in April, we have taken a decision. The first suspension is October 2024. The second one is in January 2025. So there is an order till January, he was under suspension. In January, they have to take a fresh decision. They did not take a fresh decision. The extension was only till April. In April, my lord, there was nothing on record. We filed an affidavit here saying that they have not extended the suspension. Therefore, we should be taken back. Now, in that circumstances, my lord, in July, they filed an affidavit saying that in 24th of April, we have taken a decision and we are continuing with the suspension. So this is, according to me, is post facto, my lord, because once I came before this court and pointed out, then they have taken a decision. So that 30 days, they cannot revert it back to that position, my lord. I have judgments on this point, my lord, because then the suspension becomes invalid. And secondly, my lord, if it is not communicated, because suspension order has a civil consequence, my lord, unless it is communicated to the person who is affected, that order cannot take effect. Now, my lord, before I proceed with the matter, may I give a list of dates, my lord, which will just show the facts of the case, my lord. I will take your lordship to the facts. Lordship will see, I've just narrated the facts there. They have filed. Yes, they have filed. They have filed 2 affidavits, in fact, my lord. They wanted to withdraw 1 affidavit, then file, but court did not permit them, because your lordship will see the last but one order, which was the 19th of June order. That order records that no further adjournment will be given, because previously, 3-4 dates, the adjournments were granted.
Order date?
19th of June. Second parameter, it is made clear if the affidavit in opposition is not filed by the next date, the court may consider the proceedings proceeding with the matter on the basis of the material available. Learned counsel shall also produce the relevant records along with that. So this was the direction, they have filed all the records along with their affidavit. After that, 21st of July is the last order. There they wanted to withdraw that affidavit and file a fresh one. But the court said, I will not allow you to withdraw. If you want to file a fresh affidavit, you can file. Which again they have filed, but it doesn't change anything. Materially, on facts, it doesn't change anything. May I take your lordship through the list of dates, Yes. He was initially as principal of Jorhat Engineering College. That is at serial number 1 I have mentioned. Subsequently, he was transferred to Assam Engineering College, and he was holding the post from 2011 to 2012, my lord. He was holding the post from 2011 till his suspension. And previous to that, my lord, compulsory leave in 23rd of in June 2023. So, my lord, he was also holding the additional charge of Director of Technical Education in between those periods, my lord. I have mentioned those periods, 2011 to 2017 and 2019 to 2022. Now, serial number 2, my lord, is 13th of February 2017. In that year, my lord, government took a decision to start 11 polytechnics and 1 engineering college at one go. So therefore, immediately there was a need, because AICT has to be approached for approval. So faculty has to be in place, the infrastructure has to be in place. So therefore, my lord, a decision was taken. Large number of faculties had to be engaged part-time. So this decision, my lord, of 2017, since he was holding the additional charge of Director of Technical Education, all the steps were taken by him at that point in time. Now, no complaint from anywhere, my lord, till 2024. Now, once this court, my lord, set aside that order of compulsory leave, what they do, they show one inquiry being done in February 2024. Based on that inquiry, they say you are suspended from October 2024. So, my lord, I am saying first 2007, even if there is certain allegation, I'm not saying the DP may go on, my lord. There's no problem with the DP, but they cannot keep me out of the office, because what is happening, I'm retiring in 2027. By way of keeping me out of office, by 2 years, they have kept me out of office. So they are making the process itself is the punishment, my lord. And I will show, my lord, the decision, the review decision, the minutes of meeting, there's nothing. They only repeat the copy paste and they say, in the interest of the disciplinary proceedings, the suspension is continued. They do not take into account my reply saying that all these are wrong. Prima facie, they have to take a view, my lord. DP is the final authority, I agree, my lord. Because even in the suspension, the authority has to take a prima facie view of the material available. If there's nothing, there is not even a word, my lord, which says they have considered those materials. And secondly, my lord, they only say the DP is continuing, but they have to take the stage also because they are saying I may influence the DP. But the cross-examination evidence is over in the DP. They are not passing any order. They are not coming up with inquiry. So if the cross-examination is over, how can I influence the DP? So there is no application of mine. All three subsequent extensions, that cross-examination is over in somewhere in May, my lord, in the month of May. Yes, my lord. Well, their witnesses cross-examination was over much before that. It was my, few of them was there, few my witnesses, that was there. And the cross was over. Lordship may see those three orders. Yes, my lord. There are three charges. I'll straight away. First is, my lord, they have to come up with the inquiry officer has to come up with a report of the finding of his on the charges. He has to give a report. Yes. Lord, exact date I don't remember, but it was in May 2025 this year. No, they have not done it. They have not till date. They have not done it. They, in fact, in the earlier round also, the earlier DP, the previous DP, till date they have not yet taken a decision. The inquiry report there has come after a delay of 1.5 years, but till date they have not taken a decision. And here also, 2017, the allegations are that I have engaged part-time without following government rules. I have annexed because in their reply they have stated all this on merit. So prima facie I have annexed all those documents. Every step advertised, it was published in the website. Everything, committee was formed, Now, retrospectively, they are saying we have not done this, we have not done that. There was no government guidelines for that in 2017. And those people who have been engaged at that point in time, they are continuing. Government is still extending. The first charge, just for worship, is the engagement of the part-time faculty. Second is repeated engagement of the part-time faculty. That is another charge. So that charge, my lord, is also there, also continuing. So why I am being singled out? And the inquiry report also, my lord, talks about other principles. They have only singled me out. This has only started because of the June 2023 incident, my lord, that unfortunate incident where 7 students of the engineering college has expired, my lord, in a unfortunate car crash, my lord. And after that, my lord, he was placed on compulsory leave and he has been singled out and this is going on, my lord. I will place the fact, my lord, after the recess. Very well. May I please? Lord, I'll take a maximum. Yes, my lord. So, my lord, 20, half an hour max, maximum. Half an hour. 20, I will try to wrap up because I have given the background. I will just show the charges, reply, and the case law. 3-4 case law. So I've pointed out the paragraphs also. 20 minutes. I'll. Very good. So now, my lord, in the background, what I have stated, my lord, lordship may come to the suspension order, the first suspension order, that is at page number of the writ petition 140, annexure 12. So here the charges are mentioned, and then I'm suspended. This is dated 24th, 30th of October 2024. Page number 140. This is parallelly, my lord, the writ petition.
Where the date is?
My lord, this is
Annexure 12.
annexure 12. Yes, 140. Page number 140 on the right hand side top. My lord. 140. Yes. My lord. So this is, my lord, in the parallelly the writ petition was going on, the judgment was reserved. My compulsory leave was under challenge, which was quashed in December. So this is in between, they issue this order. Now kindly have this, whereas an enquiry bearing report number so-and-so dated 14th of February 2024, received from then additional Chief Secretary, Higher Education Department regarding violation of the rules and procedure in engagement of part-time guest faculties in Engineering College and Polytechnics of Assam by Dr. Atul Bora, the then Director of Technical Education, Assam, and then Chairman of the Selection Committee. And number one, this is the first charge. Whereas it has been found from the enquiry report that the minutes of the meeting of the selection committee constituted for the selection of part-time faculties and also the final select list were not drawn out by the selection committee, thereby initiating the procedural selection. This is for one charge. Charge number two, whereas the guidelines and conditions for enhanced rate of remuneration for part-time faculty issued by Dr. Bora, then Director of Technical Education, by letter number so-and-so dated 24th of March 2021, the part-time faculties already engaged in engineering college and polytechnics were to be entitled to be enhanced rate of remuneration only if they fulfill the eligibility criteria as per AICTE norms and satisfactory track record of the performance, which were to be scrutinized by a screening committee. Now, this screening committee, I'll show the reply and the letter also. This only applies to the part-time people selected by the principals of certain colleges, not to the Director of Technical Education. 3, my lord. Whereas, I'm reading below, my lord. Whereas the minutes of the above mentioned screening committee was also not drawn up, thereby violating the screening committee procedure and also violating the above mentioned guidelines. Whereas as per the undertaking submitted by the part-time faculty, guest faculties in light of the above mentioned guidelines, it was undertaken to receive the remuneration at the enhanced rate, subject to the condition they will not claim for regularization job facing APSC as per norms. And whereas Dr. Atul Bora, the then Director of Technical Education, in spite of frequent violation of undertaking by the candidates by repeatedly claiming regularization by job by resorting to litigation against the government, could not take any action against them. So, they are saying, the teachers went to court for regularization. I should have taken action. How can I take action, my lord, for somebody, a citizen of the country, going to court, taking a legal recourse? Can I take an action? Can there be an undertaking of such an undertaking by the government saying, if you go to court, we will remove you? It is totally against the law, my lord. It can't be. This is against the fundamental foundation of the principles of law, my lord. Number 4, my lord, the last para. Whereas fresh engagement process was not undertaken by Dr. Atul Bora after completion of initial engagement of the part-time guest faculties for a period of 6 months, but rather he repeatedly issued engagement letters to the same incumbents after 6 months without any break, which is a clear violation of the provisions of the government guidelines and item. Now here, my lord, the same people, he was there till 2022. The same people till today are being repeatedly engaged by the present director. I will show one cabinet decision saying that they should be continued in the interest of the academic career of the students. They are continuing, but they are charge sheeting me for this. Till now, they are continuing. Now, my lord, next page. Now, therefore, pending drawal of departmental proceedings, Dr. Atul Bora, the then Director of Technical Education and then Chairman of the Selection Committee, now Principal on leave, Assam Engineering College, Guwahati, is placed under suspension from the service in exercise of powers under 6(1) of the Assam Rules, Discipline Appeal Rules, with immediate effect. The headquarter and during this period suspension shall be Guwahati and he shall not leave the headquarters. So therefore, Millard, I am suspended because of these incidents. Most of them take place in 2017, the suspension in 2004 after 7 years. And Millard, each and every allegation, Millard, in my reply, which is at page 157, Millard. That is my reply. I have given 2 replies, one in November 2024, page number 157. In fact, Lordship may come to page 162. That is the main reply. It's a detailed reply. Because I'm only taking a lordship to the prima facie because ultimately I'm aware, the DP will take a decision. We cannot overreach the DP, but then the authorities has to take a decision and they have to take this decision repeatedly. Page 162. Charge 1, lordship has seen that. Charge 1 is mentioned in bold. Just below that, two paragraphs below that, I as then DTE got involved in the matter of part-time faculties. Lordship has that line. Yes, for implementation of the government declaration for commencement of academic session of 11 new polytechnics and Barak Valley Engineering College in 2017, for which the government was pleased to accord permission to engage part-time faculties till regular faculties are appointed against the created posts. By letter dated so and so. He has mentioned the letter. I have annexed the letter also, Miller. This itself clarifies that all charges against me are misdirected and that have jolted me with profound shock. Next line, next para. Specific permission to engage the part-time faculties were obtained from the government in spite of above cited existing notification of the government for engagement of part-time faculties. This was done as the compelling circumstances since the APSC failed to provide the selected recommended list of candidates for this institute. Look, APSC had to select Milord, but time was short. APSC issued advertisement, they could not complete the recruitment process. In the meantime, with government permission, we have engaged them. Milord, last 5 lines from the bottom of that page, Milord. It may kindly be noted that government has not constituted any selection committee for selection of part-time faculties. The then DT himself constituted selection committee with DT as the chairman, with distinguished academicians of the state as member of the committee and subcommittees to select large number of part-time faculties out of huge number of candidates applied online. For the 12 new institutions, the advertisement was published in the newspaper and the candidates were shortlisted based on competitive qualifying marks with basic norms as per the AICT UGC for final interview and selection, which was published online for the knowledge of the candidates. The minutes of details in the form of attendee and signature of the committee members in the relative score of the final select list of candidates were in custody of the then Joint Director of Technical Education, so and so, and the same was displayed. And then the additional Chief Secretary Higher Education, Dr. So and so, and then the OSD, Dr. So and so, in my presence. It remains unclear if the same has been taken into consideration while making the report you have cited and attached without giving the annexures, as well as my explanation is clarified in this reply. The advertisement, list of shortlisted candidates, final list of selected candidates as recovered from my old system has been attached, so and so, Milord. So everything, Milord, is part of the record. If the record is not there, it is not placed before the inquiry committee, the discrete inquiry which took place by the additional chief secretary. How can he come to this conclusion, Milord? So therefore, Milord, I place this everything. In November, I place it. In March also, I place it. Now, this is the first charge, Milord. The main substance of the charge is this, 2017. Second charge, Milord, is that in 2021, what I do, Milord, I take a decision that the remuneration of this part-time faculties will be enhanced. Now, Milord, there is a government circular earlier. Before enhancing,
order and
yes, Milord. No, Milord, I'm not asking. I'm just saying, Milord, because since they have given me a charge sheet, I have filed a reply in November, in March. Now, when I take the lordship to the order of suspension and review of the suspension orders, Milord, nothing has been referred. Very well. Very well. Now, lordship will see, Milord, that first review order is at the same volume, Milord. Read petition I have annexed 176. 176. It is annexure 21. Actually, Milord, I'm sorry. This is the order by which I'm being communicated. The review minutes of meeting, Milord, is separately they have annexed in their reply, which is filed on 19th of July, Milord, this year, 19th of July. There is a additional affidavit in opposition which they have filed, Milord. 19th of July, Milord, 2025, they have filed this. That there, Milord, annexure 2, page 243.
The first review order.
Yes, Milord. Milord, 243. So, Milord, this is the minutes. So I'll just read, Milord. The meeting was chaired by so-and-so IS Secretary Higher Education. At the outset of the meeting, he welcomed the members meeting. The review meeting on suspension orders was held as per provisions of the Personnel Department, OM dated 4th of February 2020. The Secretary of the Assam Higher Secondary Education, so-and-so, briefly explained the purpose of the meeting and apprised about the present status of the suspension order in respect of Dr. Atul Bora, Principal, who was suspended by notification dated October, 30th October 2024. The period of suspension will complete by 90 days, that is 27th of January 2025. The meeting discussed regarding the current status of the suspension of the officer, and after threadbare discussion, the following decision is taken. It was decided to extend the period of the suspension in respect of so-and-so principal for another 90 days with effect from 28th of January 2025, as it is apprehended that if the officer is reinstated into service, he may exert undue influence on the departmental proceedings already initiated against him. So this is the first observation. They're saying, I may influence the department proceeding. Now, my lord, next, because every 3 months they have to do it. They have done it again on 22nd of February, which your lordship will find the page number 246.
On what basis they have added
There are no material mail, nothing. They are not discussing anything. My reply was there in November. My reply was, I've shown, read part of it, my lord. In November 2024, when they charge sheeted me, I filed a detailed reply annexing all documents, showing that these documents are there. It was not placed before the additional chief secretary and then the inquiry committee. Therefore, these charges have come. That also not taken into account. Nothing has been mentioned here. It is a cryptic order, one line saying we have seen. Therefore, we apprehend that he may influence. Therefore, we extend it. That is the only thing, my lord. Now, my lord, if this apprehension continues without any change, even this paragraph, this copy paste, only the name has changed and the date has changed. Subsequent 2 other review meetings. Second review meeting, my lord, kindly have 246. Annexure, my lord, 4. So, my lord, it is identical, my lord. She will see, I am not reading it. Last decision, last para, copy paste, only the date has changed. The meeting discussed regarding the current status of the suspension of the officer. After threadbare discussion, the following decision was taken. So, my lord, exactly the comma, full stop, everything is same. They are also saying apprehended that if the officer is reinstated into service, he may exert undue influence of the departmental proceedings. Now, my lord, by this time, this decision was taken on 22nd of April 2025. By this time, my lord, March, I have the date now, my lord, March, the evidence of the department was over. My evidence was also over. It was only I called the additional chief secretary. That evidence was only left in March. Now, even then, they are saying that this is he may influence. When the 99% of the evidence is over, my lord, in March itself. Now, my lord, the third one, my lord, the third one, my lord, is dated 19th of July 2025. So this, my lord, again, my lord, they have filed a additional affidavit. Which is the date of the additional affidavit? 29th of July, my lord. They have filed another additional affidavit because they wanted to withdraw the earlier affidavit and file a fresh one. The court said no. Here, my lord, the last extension in July. Lordship will find at page 276. Annexure 8, my lord. Lordship has it. Annexure 8, my lord, page 276. Yes, my lord. Now, it is, my lord, identical. Again, same copy paste. In July also, my lord. In July, my lord, everything was over. Evidence concluded, everything is concluded. And they are not taking any decision. They are just prolonging the inquiry. My retirement is there, my lord. They want to make me suffer and make me stay away from the office, my lord. That is the punishment they want to. Because after all, my lord, the charges, if your lordship see, my lord, it will not stand. But at least prima facie, my lord, I have shown because documents I can take your lordship, but as your lordship is right, my lord, why to go into merit of each and everything? But those documents are filed and it is clear that all decision was taken subsequent to government decision. And my lord, 2017, when he is not even the director of technical education, he is the principal of a college. How he can influence and how he can influence the disciplinary authority, my lord? Now, my lord, there's one more point, my lord. This orders, my lord, the last 2 reviews on 22nd of April and on July, my lord, that is 19th of July, my lord. This 22nd of April, my lord, they did not communicate to me. I filed an additional affidavit, my lord, before this court in June, where, my lord, I say that they have not extended it. Every 90 days, they have to extend it, my lord. They have not extended it. So, therefore, my suspension has lapsed. So what they do, my lord, when they file their reply, counter affidavit in six,
Order not communicated.
not communicated to me.
Order.
My lord, specifically 24th of April order. Because if the chain breaks, my lord, subsequent renewal or subsequent review will not help. The chain, according to me, broke on 22nd of April 2024. Because this was, I have filed an additional affidavit. This was sent to me in July. Lordship will see, my lord, that affidavit which I have filed on 16th of July, my lord, I have filed an affidavit.
Page number.
Page number 220, my lord. Paragraph 7. Lordship has that. Page number 20, 220, 220, my lord, 220. This is my affidavit of 16th of July.
Paragraph given.
7. Paragraph 7, my lord. Subsequently, the petitioner submitted a detailed representation on so-and-so seeking reinstatement on the ground there was no formal extension of the suspension beyond 27th of April 2025. A notification dated April 2025 was received by the petitioner only on 10th of July 2025. The notification bearing number so-and-so dated nil purported to extend the petitioner's suspension after a further period of 90 days from 28th of April 2025 until further orders, thereby raising a serious and bona fide apprehension that the notification was issued post facto in response to the petitioner's reinstatement request and to cover up the lapse in procedural compliance.
Sir, they have filed.
No, they have not. They have filed their additional affidavit after this, but they are silent on this. They are completely silent on this because they have filed their additional affidavit on 27th of July, my lord. This is 16 July, 29 July, 29 July, my lord. But they are silent on this. So, my lord, my main, I just to recap, my lord, the suspension order was taken in subsequently. They have not taken the subsequent incidents, my lord. That is my first point because evidence is over. My reply was there. They did not take. There is nothing on merit. They have not considered any material, and they have taken a cryptic decision and repeating that decision. That is one, my lord. Secondly, my lord, suspension order was not communicated to me in time, and therefore the chain breaks, my lord. It cannot subsequent post facto or post dated, or even if they do the retrospective revision will not allow. That judgment is there outside the judge. Review of suspension order is after thought and post facto, my lord. So these are on the procedural aspect I am saying, my lord. And on merit, my lord, I'm not taking your lordship to the each and everything, my lord. I'm only saying, my lord, 7 years, after 7 years of those incidents, my lord. So after 7 years, he is not even in that post, in that department. He is a principal of some other college. How can he influence, my lord? The fundamental rule, my lord, that the sphere of influence, that he should be removed from the sphere of influence. He should not be in a position to influence. He is not even there in the office, my lord. And secondly, my lord, that the fair and smooth disciplinary proceedings. That is the two fundamental rules, my lord. And they have to apply their mind before suspending and continue to suspend, my lord. 2 years has taken place, my lord. Even after 2 years, my lord, the DPs are not over. I am kept under suspension, my lord. Straight away, my lord, I will take your lordship to the judgment. Only 3-4 judgment, my lord. First, my lord, is the Union of India and Ashok Agarwal. Here, my lord, paragraph 21 and 22. Lordship may just mark it, my lord. And here, my lord, there's serious offenses, my lord, defalcation of money, FIR, those type of cases, my lord. There also, Supreme Court, my lord, has interfered. My lord, 21 and 22. So I'll just read out, my lord, the power of suspension should not be exercised in an arbitrary manner and without any reasonable ground or as vindictive misuse of power. Suspension should be made only in a case where there is a strong prima facie case against the delinquent employee and the allegations involving moral turpitude, grave misconduct, or indiscipline or refusal to carry out orders of superior authority are there. Or there is a strong prima facie case against him if proved would ordinarily result in reduction in rank, removal, or dismissal from service. The authority should also take into account all available material as to whether in a given case it is advisable to allow the delinquent to continue to perform his duties in the office, or his retention in the office is likely to hamper or frustrate the inquiry. So these are all parameters they have to take into account. None of this is considered. 22, Miller. In view of the above, the law on the issue can be summarized to the effect that the suspension order can be passed by the competent authority considering the gravity of the alleged misconduct, that is serious act of omission or commission, and the nature of evidence available. It cannot be actuated by malified arbitrariness or for ulterior purpose. Effect on public interest due to the employee's continuation in office also relevant for determining factor. The facts of each case has to be taken into consideration as to formula, as no formula of universal application can be laid down in this regard. However, suspension order should be passed only where there is a prima facie case against the delinquent, and if the charges stand proved would ordinarily warrant imposition of a major punishment, removal, dismissal from service, or reduction in rank. Now, my lord, next one is, my lord, Ajay Kumar Chaudhary. My lord, here, my lord, the paragraphs are, this is a very famous judgment, my lord. I need not take your lordship. The paragraphs, lordship may note the paragraph. My lord, paragraph 11, 12, and 21. My lord, this is the case, my lord, where they say, my lord, that 90 days you have to review, because there cannot be an indefinite suspension. And after this judgment, my lord, many of the service rules and the disciplinary rules were amended, or by notification, these provisions were incorporated that 90 days or 180 days, some of them, there is 180 days, it has to be reviewed. It cannot be continuous. So I'm not going into, my lord, I'm not reading because the time is short, my lord. I have para 11, 12, and 21, my lord. The next is, my lord, this is important, my lord. This is 1999 6 SSC. My lord, here, my lord, what happens? The selective nature of the disciplinary proceedings, my lord, because the inquiry report says that this number of people had the lapses because of this people. But on the DP was initiated only against one. The paragraph, my lord, is paragraph number 7 and 8. I'm not reading it, my lord. Why I'm saying this, my lord? Your lordship may see the inquiry report, the initial inquiry report, the discrete inquiry report by the additional chief secretary, my lord. That I have annexed, my lord. Just for a minute, my lord, I will just take your lordship to that one. That discrete inquiry, my lord, is at page number, where, my lord, the additional chief secretary says that this number of people are involved, the principals are also involved. But I have been picked up, my lord. No disciplinary against the others, my lord. So that is what I'm showing, my lord. That inquiry I have filed in my additional affidavit. Just one moment, my lord. I will just pick that up. I will give that page number, my lord. I will give that page number separately, my lord. Now, next one is, my lord. Page number there. This is that Dipali Mali, that judgment, my lord, where para 10 and para 11, my lord. Here also, my lord, this is a judgment, my lord, where they say, my lord, if it is not done within 90 days, because the earlier judgment of Ajay Kumar Chaudhary sets the 90 days deadline, every 90 days review. This says, my lord, para 10 and 11, that if it is not done within 90 days and it is done beyond 90 days, then it will not cover the defect. It cannot be retrospective. It has to take place within 90 days. Otherwise, the chain is gone. This is the judgment, my lord, on this. And Deepak Mali, finally, this was 2018, 7. This is a specific case, my lord, on facts, where, my lord, the person was under suspension for a long time. Paragraph 24, 25, 26, and 27, my lord. Serious allegation, my lord, of an IPS officer, Inspector General of Police, of kidnapping. An FIR was filed against the Inspector General of kidnapping someone. Now, my lord, 24, 25, 26, these are the observations, my lord. I'll just read, my lord. This is in context of I will read 25 only, my lord. The first respondent has been under suspension more than 6 years. While releasing the first respondent on bail, liberty was given to the investigating agency to approach the court in case he indulged in tampering with the evidence. Admittedly, no complaint is made by CBI in this regard. Even now, the appellant has no case that there is any specific instance of any attempt by the first respondent to tamper evidence. In the minutes of the review committee meeting held on 27th of 6, 2016, it was mentioned that the first respondent is capable of exerting pressure and influencing witness, and there is every likelihood of first respondent misusing office if he is reinstated as Inspector General of Police. Only on the basis of the minutes of the review committee meeting, the Principal Secretary Department ordered extension of the period of suspension for a period of 180 days beyond so and so. This court in Ajay Kumar Chaudhary and Union of India has frowned upon the practice of protracted suspension and held that suspension must be necessarily be for a short duration. On the basis of the material on record, we are convinced that no useful purpose would be served by continuing the first respondent under suspension any longer, and he is reinstated, my lord. So, in a serious case like this, my lord, though, my lord, it was 6 years, yes, but my case is even worse, my lord. I am retiring. Even if I am 2 years, my lord, but my retirement is there, my lord. If it is proportionally compared, my lord, my case will be much graver, my lord. My lord, this I rest on this, my lord, and that paragraph, my lord, I will give the page number, my lord, and the annexure number, where the additional chief secretary has named so many people. I have been only picked up for the action. Grateful.
Madam.
My first submission would be that this week. Yes, sir. Yes, sir. Malad, this is with respect to another incident, Malad, not related to this suspension. This is not related to this suspension.
Review of the
In
that it was not the time.
well, it is within the time limit, Malad. My annexers says so, Malad. In annexers, annex with the second additional affidavit in opposition, Malad. Starting from page number.
But even not file any like
But I have, Malad, filed a minus to the meetings where dates were there. These are all within 90 days, Malad. Yes.
when it was
Malad, communicated date is not there, but it has been communicated as the order shows, Malad, this copy to the petitioner, Malad.
but you cannot say the date on
Regarding service report, Malad. Sorry, Malad. Sorry, Malad.
extent
Yes.
review of the order
Yes, Malad.
when it was communicated to the petitioner,
This service report I don't have, Malad. Right.
then you tell me what is the basis of arising as a conclusion that will influence the
Malad, the allegations there in,
exercise of
yes, Malad, here the allegations is, Malad, illegal appointment, Malad. Illegal appointment or procedural defect in appointing this, Malad.
what material was available for the review of what is the basis
Basis, Malad, because he was known to other persons with the department, Malad.
that's
Then
right, but is
then
there any material before it?
material, Malad, this minutes of the meeting materials are not annexed, Malad. That doesn't mean, Malad, the materials are not there, because
No,
here
material is there. You have to put it with, like, that there the material.
but here
Based
reason
upon which that conclusion was
is
arrived.
apprehension, madam.
Yes.
My lord, apprehension is there because, my lord, this person, he has been working as a director, my lord, for a long time in the director of technical education, my lord. Now, since the departmental proceeding has been conducted in by the director and the secretary level, my lord, he is known to known to other persons, my lord, and that was one of the apprehensions that he may influence the.
No, he was
with-
not in the office.
Yes.
He transferred 2022 as a principal. He was not director any longer.
But my one submission would be that, my lord, another submission that writ petition is not maintainable because, my lord, the petitioner has been suspended. Currently have page 253, my lord, 253 para 5, which I am relying, my lord. The petitioner has been
Page number
253, my lord. My additional affidavit.
Yes.
Well, he has been suspended under Rule 6.1 of the Assam Service Disciplinary Appeal Rules, my lord. And as per Rule 14, he has a remedy for appeal, my lord, against the before the government. And my submission is that since there is a provision in the statute to approach before the appellate authority, the petitioner ought to have approached the appellate authority before coming before this honorable court. And for that, my lord, I want to rely upon one judgment. I think that is already on the file, my lord. On last occasion, I have already this 2022 17 SCC 332.
not available.
Yes, yes.
Any other?
Yes, yes. Relying upon para 6 and 8, my lord, that I have already marked, which says that this is jurisdiction under 226 is not a shortcut, my lord. The petitioner must have approached the or availed the remedy which is available to him before approaching the. Yes, ma'am. And in additional affidavit, I will be relying upon para 12, my lord, 257, page number 257. Para 12 in 257 start, my lord, 251 is start from 251.
12.
12, 13, 14, 16, my lord. No, that's
only on this, my lord, alternative remedy, my lord, just to
Yes.
rebut, my lord. I'm saying, my lord, there is no power, my lord, of writ jurisdiction, my lord, because even if there is alternative remedy, my lord, in an appropriate case, my lord can exercise the power. Now, in this case, why it should be exercised, my lord? My very grievance is, my lord, is because of that incident, my lord, everybody is sad about that incident. It was not in his control. The accident took place outside the college campus, my lord. So therefore, my lord, we cannot, and then after that, my lord, he has been kept out of suspension. Even if I file an appeal, my lord, my main grievance is they are delaying it. They want to keep me out of the office.
Accident is not the issue here, my lord.
My lord, I'm saying that
It's
is the
different.
genesis because first DP was initiated, they failed to, I could quash the compulsory out of office, my lord, the suspension. Then they said ki second DP. So there is a chain, my lord. Therefore, I'm saying even if I file an appeal, my lord, it will be fait accompli, my lord. They will not decide it. They will keep it pending. Even my revision, the revision of my suspension, they have not communicated, my lord. That would have continued another long years, my lord. It would have been fait accompli, my lord, going before and filing it, my lord. Because I'm not challenging the DP. I'm only challenging the suspension order, saying that they are delaying the entire process. I'm not saying ki don't do DP, may not examine the DP, pass an order. They may not one para 16 of their affidavit, may not, they themselves say in the original, the first DP, the inquiry report has come in June. Till date, my lord, they have not sought anything. They have not asked, taken any decision. Para 16 of their first affidavit of 19th of July. So that shows, my lord, how they are trying to protract the disciplinary proceedings.
First affidavit, third one, page number.
Page number, my lord, 237,
These documents are, I think,
para 16
uh,
of the 19th of July affidavit. 237, page number, para 16. They say my copy also they have annexed, 13th of June, that inquiry report submitted, inquiry officer submitted inquiry report. Till date, they have not taken any decision. So therefore, I am saying if I file my appeal, they will keep it pending, my lord. So it will be fait accompli, my lord. Only showing procedure and rules, my lord. I cannot be kept out of office, my lord. I have shown all the procedural errors. And, my lord, this point was raised by my learned friend first day, my lord. And after that series of orders, my lord, lordship will see they were asked to produce the record. And they have given last opportunity. If it is not produced and affidavit is not filed, we'll proceed on the basis. That order I have shown, my lord. So it shows, my lord, the much order has flown, my lord. It cannot be on the basis of that rule.
Third.
Grateful, my lord.
Yes, sir.
but kindly rely upon on the second affidavit. मतलब earlier affidavit, there are some मतलब incorrect, मतलब some actually some annexes were annexed along with some other facts, मतलब. That's why I filed without changing anything, मतलब. The inquiry
Both
report,
the affidavits are there.
he has seen, मतलब, there is
So factually, there is nothing wrong, my lord, but both the affidavits is before the court, my lord. Court
Otherwise,
will examine both the affidavits, my
relying
lord.
upon that affidavit, it may, मतलब, create some factual dispute.
Okay.
And this documents is all available in the second affidavit also. The inquiry report which has been completed in earlier DP1.
Grateful.
Whether there
Yes, your lordship. It may dispose of a representation after re-verification of the documents.
Obliged.
Deeply obliged.
My lord, petitioner was initially appointed as an assistant teacher under the SSA, my lord. Page 22 is my appointment order. As a on contractual basis. And thereafter, my lord, when I was serving as a contractual teacher, then in terms of a selection process, page 23, I was appointed as BRB, that means block resource person. Block resource person, the function of the block resource person is to monitor the activities of the school of the block and to monitor the activities of the CRCC, which are junior to my post, my lord. Then as a DRP. Buddha. As a DRP, my lord, I have been discharging various kind of duties, my lord, from page 37. Page 37, first order for discharging my duties. Last name 6, serial number South Salmara. My name is Kamal Hussain, DRP South Salmara. Then page 38, serial number 3 as DRP. Then page 39, serial number 81, DRP. Then my lord, page 43, serial number 81, DRP. Block resource person, that means my lord. Then page my lord 47 also, DRP. And in 2025, page 48. Page 48, my name is reflected as serial number 19, South Salmara, Kamal Hussain, DRP, South Salmara. Then I have been also engaged as presiding officer in the last office, my lord, last on-site election. Then my lord, page 53. My lord, then my lord, I'll come to the page 61. Page 61. This is the impugned order. While I'm serving as the BRT, block resource person, in a particular block, South Salmara block, some person who are working as a CRCC, who is junior to me as per the hierarchy of the post, has been allowed to do some additional post in which I have been discharging for last 10 years. Page 61. No, you have no vested right to remain post. My lord, I have been doing the similar nature of work till today. I have not been removed. Presently, I am doing a particular work in a particular manner as per the direction issued by the mission director of Samagra Shiksha. Then some junior person, the authority who is are not competent, page 61.
My lord, so far as the substantive post of the petitioner is concerned, that has not been disturbed. Yes, no, nobody has disturbed that, my lord. He was holding an additional thought. Now it has been given to a third person.
I am also,
That he cannot, my lord, claim it as a matter of right that he should also be given that additional. Nobody is disturbing the, my lord, post which he is holding.
My lord, there is a
And
class.
to my information, my lord, so far as the private respondent is concerned, he has already joined.
My lord, there is a class between myself and the
Lordship will issue notice, my lord. Will
until then,
clarify.
that may be,
Yes, my lord.
that may be stayed, my lord, till the next day, my lord. Page 61. If the person already joined there, then my lord, in my post, my lord, he is junior.
No, not to
hierarchy.
his in his post.
My lord, academic, my lord, same block, South Salmara.
Oh, that's a different. Lord, you will see, my lord, that bracket, my lord. It says, my lord, BRP academic.
There is no post of BRP academic.
And my lord, page 23, Lord, you will see in the petitioner's case, it is BRP arts and social science. So that is his part.
There is no post of academic, my lord.
It
Page,
is there in the record. Page 23, Lord, you will see.
my lord, page 34. There is no such
23.
post. There are 4 numbers of posts.
Lord, you will
BRP
see
mathematics.
post, my lord, RP for arts and social science. Now, my lord,
Page
page
34. There are
61.
page 34. There are only 4 numbers of posts. There is no post of academic in charge, my lord.
Lord, you will say subject to outcome, my lord. Subject to outcome of the petition, my lord, at base. Subject to outcome, my lord. The posting of the respondent number 6 in the additional search will be subject to outcome of the at base. Don't go there.
I'm appealing for money. I'm appealing for one. If you can, for money.
5, 4, 3, 3 and 3. 3, 4 and 3, 4 and 3.
1 and 2.
That's matter. by the right order that just in the of we have taken of part the private in private
One more high school, right?
part taken how much private respondent yeah
Yes, that is my lord respondent six is presently given the additional charge.
state of taken for how much those are that is the order by number as operated by in the specific
Charge what?
or subject outcome of it of
Doctor, instead of joint lordship will say has respondent six has taken over charge because it is additional charge.
My lord, one observation may be made, my lord. My service may not be disturbed, my lord, as per page 23, since I have been doing the work for last 8 years, 10 years. My service, present service shall not be disturbed.
Nobody is disturbing, my lord. No impugn order is there. Disturb the service.
If somebody has come in my place, that definitely I will be no work.
your substantive always
Yes,
there.
my lord. As per BRP, my lord. As a BRP, my service shall not be disturbed.
Please, your lord. Lordship, hearing the petitioners, they were originally appointed in the year 1998 or 1996, lordship, as teachers in different government schools, lordship. Thereafter, lordship, they were paid salaries for some period of time. Thereafter, the salaries were stopped, but they were never discharged from their service. Eventually, your lordship, they were given the status of tutors by orders dated 30th January 2021 at a fixed salary of 10,800 rupees, lordship. And thereafter, lordship, our contention is that we should not have been accommodated as tutors, but as teachers, lordship, because we fulfill the criteria for appointment as teachers. And lordship, another aspect is that the provision of law under which we have been accommodated, that would not be applicable to us because that applies to venture schools, lordship, not to government schools. So, lordship, at this stage, I'm only praying for issuance of notice.
My lord, notice will only go, my lord, and your lordship sees page 28, which is referring to. There, my lord, at the bottom line itself, they have said, my lord, they have, the petitioner, my lord, has accepted, my lord. While joining, he has taken undertaking, my lord. That also has been given. That also will be, he's already joined in, my lord, 21, January, 30th January 21 as tutor, man. So now it's 25. And my lord, that aspect also has to be taken into consideration regarding maintainability.
Lordship, there are,
Because similar cases are there, my lord. Similar batches of cases.
Alternate.
Yes, my lord.
Order declared by the direct
Same, they do.
by
Very well, very well. Permanent tutor. In order now. Effective rate, na.
all the
Okay.
of
Much obliged.
Maybe. Lord, this is Lord, fourth round of litigation. Now, Lord, finally, they have Lord, considered their case, and Lord, SLC has recommended our name in the way back Lord, 2023. But till date, they have not provincialized our service. That is the Lord, gist of the case. Now, Lordship, kindly see the SLC reference. We have Lord, annexed Lord, page 44. Page 44, Lord. And Lord, operative part, page 44A, third para, Lord. Page 44A, third para. The state level scrutiny committee examined the matter through and recommended the name of so and so, so and so, so and so, so and so. Now, till date, Malad, they have not provincialized our service. That is the Malad.
Malad, in this regard, I have obtained one instruction, and as per that instruction, it is stated that proposal was examined at various level of the government. Upon thorough scrutiny of the records, the government filed letter number so and so dated 19/11/2024, directed the undersigned to furnish specific views in the individual cases to ascertain the correctness of the proposal. Accordingly, a detailed statement along with individual case-wise opinions slash views was submitted to the government filed letter number so and so dated 23/12/2024. At present, further action from the office will be taken upon receipt of necessary instructions from the government. So now it is lying in the government offices, madam, under government, madam.
Sir.
So sometime may be granted so that I can obtain the status of this matter, my lord.
I lettered for three
Yes.
and the department got I saw their for provincialization of their service. And why for last year
So the matter was examined in various level
there
and
so exam the document here
On the strength of the Malad
hereafter,
said,
my lord, individual case-wise opinion was taken by the government. So, my lord, accordingly, a detailed statement along with the individual cases of opinions and views are submitted to the government on 23/12/2000.
when they that is the age of correct you will examine the document then there's correct the one person has the Act.
At least 10 days may be granted so that I can obtain the instruction from the government.
But Lordship has seen the letter 14/8/2023. In view of the letter, my lord, the earlier contempt petition has been closed. Lordship will find at page 46. What is the observation by this honorable court? There was a contempt petition earlier that has been closed in view of this letter. Page 48, Lordship, kindly see the order. There are three, my lord, the gist of the order. And my friend was, my lord, submitting, everything is okay. Now they are going to provincialize. But till day nothing has been done. So let them, my lord, take action on the SLC, my lord, within a specific period. Otherwise, these gentlemen will going to, my lord, retire if the litigation is going on and the rest is going on this way. My lord.
SLC has already recommended the matter. Madam. Here it is also stated, which reveals the case of the petition was placed before the SLC state level scrutiny committee, and the said committee upon examination had recommended the case of the petitioner for provincialization. So my lord, 10 days time may be granted. I will take the instruction from the government. My lord.
My submission will, my lord.
Are you agree with the
At least little extension of time may be required, my lord.
why? Already we have done 2 years.
4 months, my lord.
My lord. Who will be happy, my lord, if it is done within 4 months? My lord.
4 months.
Yes, my lord. My friend is agreeing, my lord. Nagi God. Further litigation. Develop, my lord.
This
May I plead the lordship? My lord, the petitioner here challenges the appointment of the private respondent as the principal of the school, my lord, because the private respondent does not fulfill the, my lord, eligibility criteria as stipulated under the relevant rules, my lord. The private respondent also, although, my lord, he was initially appointed in the year 2001, my lord, but he has been granted graduate scale only with effect from the year 2021, my lord. So to become a headmaster or principal of a school, a graduate teacher must complete 17 years of continuous service as a graduate teacher, my lord. So he has received graduate scale with effect from 2021 only. That your lordship will find at page 19 and Annexure 5, my lord.
My lord, in this case, I have filed affidavit in opposition, your lordship.
When?
Yesterday, your lordship. It is not, I think it is not checked with the case record, your lordship.
Otherwise, also in their affidavit regarding this issue, there is nothing, my lord. Because it is apparent from the face of the record, my lord. If your lordship takes up page 19, Annexure 5. Yes, my lord. Then, my lord, a short date may be given and your lordship may take up. Because...
Pass the order.
Yes, my lord, I understand.
Then my opinion.
Yes, my lord. A short date may be taken, given, my lord.
But 34. No.
A Begum, your lordship.
A
Begum. Correspondent number 4 here.
number
4.
Oh. Okay. Sorry.
Lordship, secondary education department, lordship, 1, 2, and 3.
Take up substance file or 30.
with September.
Yes, sir.
Record. By the department, by the
Lordship, here whether the writ petition is maintainable or not, your Lordship, on the next will be placing a submission, because it's not maintainable because the petitioner is not aggrieved here, Lordship, because his in earlier he was made the principal in charge, your Lordship, and that was challenged by respondent number 6, your Lordship, and there it has already been settled that the petitioner does not have the eligibility criteria, your Lordship, because she was more than 57 years of age, your Lordship. There it has already been settled that she does not have the eligibility.
I am not on
criteria,
that, my
Your
lord.
Lordship.
Quo warranto. I am praying for quo warranto. Quo warranto is maintainable against any person, because any person who is not holding, who is not eligible to hold a particular post, my lord, quo warranto lies against any person, my lord. And any person, my lord, can, whether he is aggrieved or not, he may approach before your lordship praying for a quo warranto. Because my contention is that the person holding the post of principal is not eligible to hold that post in terms of the provisions of the rule. So quo warranto will lie anyways, my lord.
May I submit, your Lordship? In fact, quo warranto petition will not be maintainable because this is only a temporary post, your Lordship, and I have a decision, your Lordship, where it is stated that quo warranto will not lie against the post which is on a temporary basis. It will lie against only a regular post, your Lordship. It's 2006-11 SSC, your Lordship. It has been made clear, your Lordship. 2006-11 SSC 731, your Lordship. Lordship.
Yes, my lord. On 5th, my lord. Obliged.
But here the instruction is awaited, my lord, not to allow me 3 weeks time to get the instruction, file my academic.
And it's okay.
Yeah.
And it's okay, my lord.
Or respond not too much.
Is it
My lord, SSA, my lord.
for a everything?
Not 3 weeks time, my lord.
My lord, kindly edit me. Kindly edit me with my lord. Obliged, my lord.
Well, here, my lord, we come for various reasons before the court. This is one of the reasons I sometimes, my lord, put myself in a very awkward position. My lord, the post for principal has fell vacant in the year 2019. The advertisement was issued in November 24 for filling up the 2 posts of principal. And as per law, my lord, the process of filling up the post has to begin prior to 1 year of the vacancy, which is to be occurred. Now, after the advertisement, now I have been told, my lord, only on 1st of July 2025, my lord, interview has been had. Now, result has not been given. So somebody.
I am for respondent number 1.
Who is it?
2 and 3 will be the appropriate person, Lordship, and they have a standing counsel, Lordship.
Who is the The last order, your lordship, this is 6/6/25. Who is it? Who is on it?
Here, the parts.
I know. This is not the number. Let it come up Tuesday next. The process, but we can't help it.
Jail or something.
Correspondent or what?
He question, no? He's coming. His name is not known. The name that नाम देखो ना. His name has not been found. Maybe. Last time also Mr. Mehdi appeared. Last time you took time. Mr. Mehdi took.
Yes, madam, perhaps my name is not shown today, madam.
And let it be next week, madam, showing his name.
Any date, madam.
Selection process.
Madam.
Well, if the results has not been declared, madam, there is no bar for declaring that. Because sometimes they do not declare it because the matter is pending for the court. Diploma. Take his number.
My lord, my service was provincialized by the Director of Secondary Education. And my lord, they were not implementing it. I approached this court. Court gave a they were not implementing the order passed by the Director of Secondary Education regarding provincialization of my service.
Who has not been?
The department was not implementing the order. So I approached this court. The court gave a direction, you implement it. So my lord, after they were not implementing, after the court's direction, I filed a contempt. At page 78, your lordship will find at page 78 in the contempt. Your lordship has got it, page 78. Second paragraph, learned counsel for the respondent has however submitted yesterday on 79/24 an order has been issued by the Director of Secondary Education as per the direction of this court. The aforesaid order reveals that the compliance of the aforesaid direction of the court dated 14/7/21, the service of the petitioner against the third hours graduate teacher in such a school in the district as per the Assam venture such and such has been moved to the appropriate government department for concurrence. It has been clarified that said order would not be treated as a precedent in other cases. So the contempt was withdrawn. Now they come over, my lord, they say the act under which I was provincialized has been set aside or repealed. Now I cannot do it. My lord, this is the order passed, my lord, because I am deemed to be provincialized. In other cases, this coordinate bench has passed orders saying that the order was already provincialized earlier, but it was stayed by a private respondent who was trying to say that he was senior. He filed a writ petition and there was a stay order. During the stay order, ultimately the writ petition by the respondent was disposed of, directing the director to dispose of who is the senior. Then ultimately it was decided that I am the senior. So ultimately government allowed me to be provincialized. Then, my lord, they were not implementing. I came before this court. Court said implement them. Then contempt was filed. They say it was sent for concurrence. It will not be taken as a precedent. Now they turn around after the contempt was withdrawn. They say no, we will not do it because you had given provincialized in the old act, and it was been. My lord, our statement is submission before this court is, my lord, we are deemed provincialized. And the similar situation, my lord, this court in page 94 has passed an order, and at page 99, the Honorable Court has said, in relying on earlier orders, they are deemed to be provincialized. From that day, it was only because of the court's order it was stayed. And the person who was provincialized, the same order was passed in page 100, another person. Same thing will
Yes.
I think subsequently an order was issued, my lord.
page 92.
Rejecting the claim of the prisoner, page 91, my lord. That is under challenge, my lord. My lord, perhaps, my lord, our affidavit is required, my lord, in this matter. We have already received an instruction, my lord. My lord, after 10 days, my lord, we will file
Only
affidavit.
thing, I am 59. My lord, provincialization done long time back. And now, my lord, after everything was done, the court gives a direction. They come in the contempt and say, we will be sending it for concurrence. That will not be precedent.
Yes, my lord. In the meantime, I will file the affidavit.
No, I just draw your attention. I am an inferior here, is a F1 number 6.
320. There is reference that
330.
Well,
yes, like that.
I was unnecessarily inferior now. That is why I am going to point out. Misunderstanding, I thought. But the last order where I have been getting the benefit, that is why I have been.
Or- or- eliminated.
Secondary duty.
Oh.
That's number 6, man.
I am F1 6.
What the report? Finance report. Educate the right. That-
My lord, fix it after in 10 days, my lord. Within a week, I will file it, my lord.
Not necessary because I clarify my thing.